All right, I will call us back to order. We are reconvening this remote hearing of the House Judiciary, Finance, and Civil Law Committee to order. Today is still March 22nd, 2022. Members, we'll keep going till we get through these bills today. The first bill on our agenda is House File 4184. Representative Long, would you like to move House File 4184 be referred to the General Register?
Yes, I would. That is my motion. Thank you, Madam Chair.
All right. Thank you, Representative Long. I also understand you have an A1 amendment. Would you like to move that amendment and tell us what it does?
Yes, please, Madam Chair. So it's a simple amendment that would remove a duplicative provision that's in the bill right now. We were giving authority to the Attorney General to enforce this, and turns out they already have that authority in state law, so we don't need this language.
Got it. All right. Representative Long moves the A1 amendment. Any discussion to the A1? All those in favor, please say aye. 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 Opposed? All right. The motion prevails and the A1 amendment is adopted. Representative Long, please tell us about your bill.
Thank you so much, Madam Chair. So, members, what do Buffalo Wild Wings, Jiffy, Lube, and Jackson Hewitt tax preparers have in common? Well, they're all franchises that once used anti-competitive no poach agreements in their franchise contracts. No poach clauses in the franchise context prohibit one franchise from hiring employees of another. So these are not agreements between employees and their employers. They're agreements between franchisees and franchisors. So the employees may never know, and they don't have any ability to negotiate around them in their contracts. This is a distinctly anti-competitive practice. How can workers improve their working conditions if they can't choose to move their work elsewhere? These types of agreements, it is clear now, are illegal, and this bill would simply prohibit this language in franchise agreements. The Department of Justice has sued many companies that were using poach clauses in the past, and state attorneys general have also settled with 100 fast food chains to remove no poach language, as Attorney General Ellison will discuss. So it's time now for Minnesota law to catch up as well. Many franchises are voluntarily dropping these provisions from their franchise contracts, but for those that don't, Minnesota should be able to enforce against those companies for this harmful practice. And with that, Madam Chair, I'd like to turn it over to my two testifiers.
All right, thank you. First on the list, I have Attorney General Keith Ellison. Please introduce yourself for the record and go ahead with your testimony.
Thank you, Madam Chair, and thank you, Ranking Member. And let me thank Representative Long for this excellent piece of legislation, long overdue and very critical in order for people to reach the American dream, quite frankly. Being able to change jobs easily is one of the best tools you have to help you afford your life. If you're underpaid, if you're treated poorly, if there's no opportunity for advancement at your current job, then getting a new job can really help. Even if you don't actually move, the fact that you could move and find another job gives you some leverage to negotiate better pay and benefits with your employer. Isn't it how a fair market should work? The problem is it doesn't always work that way and hasn't always worked that way. Employers often try to make it harder for workers to move to new jobs. They try to suppress pay and restrict competition to get an unfair advantage over workers. Representative Long's House File 4184, which would ban no poach, no hire clauses, is an important step toward creating a more equitable playing field, more equal playing field between employers and employees. The way no poach, no hire clauses usually work is that a franchisee agrees not to hire workers from other stores in the same franchise chain. For example, one McDonald's franchise couldn't hire current or former employees from other McDonald's restaurants. Sometimes they exist across chains as well. Some no poach, no hire clauses prohibit hirings for months or years after an employee leaves the previous job. For example, we know that the real no poach, no hire agreements that McDonald's used in the past prohibited hiring employees if they had worked at a different McDonald's within the past 6 months. The parties who agree to these clauses are the franchisor, meaning the corporate headquarters, and the franchisee, meaning the owner of the franchise. The important thing to know is that even though these clauses affect employees, employees don't agree to them. These clauses are not part of an employee's contract. Employees never even see these kind of provisions. This means that your employer has one of these contracts under the current state of the law. You can't do anything about it, but they're very prevalent. Dozens of fast food chains use them now and used to use them recently. From Buffalo Wild Wings to Domino's to Culver's to Jimmy John's. Outside of the fast food industry, you see this in the gym industry, hotels, salons, and even tax preparation businesses have them. Now, you'd think operators would want to hire workers from other locations in the same franchise chain. Those workers would be well qualified and require little training. But instead, no poach, no hire agreements help franchise owners to keep wages down for workers and profits up. If you're an employee, these clauses don't just hurt your wages and your ability to get ahead. They can trap you in a job where you're taken advantage of, not treated properly. There are clear cases of this that I've seen. You might be stuck in working excessive hours. You might be stuck with a manager who sexually harasses you, real case. You might be stuck, say, having your wages stolen, also real case. Or your choice might be to leave the industry entirely that you're working in, which is something that is difficult because you'd have to reskill and get familiar with a whole new way to work. And no poach, no hire clauses, these no poach, no hire clauses reward bad employers by giving them more power to keep their employees and punishes good employees by preventing them from moving somewhere where they're going to get treated better and will be appreciated more. You may be aware that attorneys general from all across this country, including Minnesota, have been investigating no poach, no hire clauses for a long time. The Minnesota Attorney General's office has gotten Arby's, Dunkin' Donuts, Five Guys, Little Caesars, and Panera to sign agreements that they will no longer use no poach, no hire clauses. House File 4184 is necessary because it makes these clauses illegal. Under current antitrust law, if two different restaurants that directly compete signed a no poach agreement with each other, it would clearly be illegal, and this wouldn't be necessary with no poach clauses. Franchises don't sign deals with other franchisees. They sign the deal with the franchisor and the owner of the whole operation. It's called a hub and spoke conspiracy, and the hub is the corporate headquarters, and the spoke is each of the individual franchises. This way, the individual spokes can claim their conduct is not technically illegal, even though the clear effect is that the franchise owners are colluding with other franchise owners. If House File 4184 gets passed, it will improve the lives of people. It's a necessary piece of legislation, and it'll make this practice unambiguously illegal. Passing House File 4184 will help Minnesota find the jobs where they're respected, treated well, and can compete to get ahead. Isn't that what we all hope for? Isn't that what we all believe the economy should be? So please support this important piece of legislation to support the lives of hardworking Minnesotans who are trying to earn their spurs just like everybody else. Thank you.
Thank you very much for your testimony. We also have another testifier on the list, Aaron Sojourner. Please introduce yourself for the record and then go ahead with your testimony.
I am Professor Aaron Sojourner. I'm a labor economist at the University of Minnesota, Carlson School of Management. And what I want to tell you about is some of the research and sort of how economists think about no poach agreements. First, I just want to say, like, the idea of these employers do not own their employees, and they can't steal employees from each other because, you know, workers are free people who make choices about where to go, what's best for them. And employers colluding behind agreements to not compete against each other, violates fundamental principles of free market competition and, creating collusion and monopoly behind closed doors to diminish competition and build market power against workers. So we see the rise of no poach agreements. They've been around a long time, but they've come into view of the field of labor economics only recently with a paper that was published just a few years ago by Orly Ashenfelter and Alan Kruger. They found that 60% of major franchises use these kinds of agreements. These are, as Attorney General Ellison said, these are organization level agreements. They're agreements between franchisors and franchisees. Workers aren't at the table. Workers are not party to these agreements. They don't have a chance to, they don't even necessarily know about these agreements. They certainly don't have a chance to negotiate as part of these agreements. They prevent workers from having the freedom to take jobs some of the jobs that they're best suited for, and having mobility in the labor market that they're best suited for. If you've worked at a McDonald's and built experience there, and then maybe you have to move for personal reasons, and you go in to apply to another franchise of the same chain, and they ask you what your work experience is, and you write down, I worked at McDonald's on the other side of town. You are, seeking out a very sensible job opportunity for you where you can be productive and you have that experience. You're being honest about that. And behind closed doors, the owners of these franchises have colluded to say, no, we're not going to compete against each other. And so you, the worker, are trying to do the right thing, and you're getting locked out by revealing that what your experience is. You're disqualifying yourself through this collusive agreement without even knowing it. There's been careful research done by economists of a very high profile no poach agreement that involved many of the major players in Silicon Valley that came to light a few years ago, including Apple and Intel, where they basically said, hey, there's too much competition for engineers, computer scientists, technical workforce. Let's not try to hire away from each other, And what you see is that it actually did reduce worker mobility. It did reduce the opportunity for workers to change jobs and find a good fit. And you could also see it in reduced wages, so that workers were actually earning less money because of these collusive agreements. So it's not just mobility reduction and finding a new job across town because your life changes circumstances. It's also suppressing market level wages and eroding workers' bargaining power in the labor market unfairly. And really, like any argument that you can think of that you could say to justify a no poach agreement, like maybe we need...
Mr. Sojourner, I'm going to need you to wrap up.
Sure, sorry. So any agreement like protecting investments in training, you should be very skeptical of, because the employer can make that agreement directly with the worker. They don't need to make that agreement behind their back. They can ask them to pay back training costs. So no poach agreements are like non-competes, but at least with non-competes, you can negotiate. This happens, you're locked out, you're not at the table. Thanks.
All right, thank you for your testimony. I don't have any other testifiers signed up, so we'll move on to member discussion. Members, any questions to the bill? All right, seeing none, Representative Long, closing comments.
Thank you so much, Madam Chair. Thank you for considering this bill. We had a bipartisan vote in the last committee stop, and I'm hoping we can have a strong bipartisan vote here too. I appreciate member support.
All right. With that, Representative Long renews his motion that House File 4184 as amended be referred to the General Register. The clerk will take the roll.
Griffin,
Aye.
Mueller,
Aye.
Scott,
No.
Feist,
Aye.
Frazier,
Aye.
Grossel,
No.
Herr,
Aye.
Hollins,
Aye.
Johnson,
No.
Liebling,
Aye.
Long,
Aye.
Mortensen,
No.
Novotny,
No.
Barr,
No.
Robbins,
No.
Bang,
Aye.
Jean.
Aye.
That is 10 ayes and 7 nays.
All right, the motion prevails and the bill is on its way to the General Register. Thank you, members, and thank you to our testifiers. It looks like the next person on our agenda is currently in another committee, so I'm gonna hop to Representative Pinto. Representative Pinto, are you ready to present your bill? I know we're skipping ahead a little bit in our order, but that's the nature of this time of session.
Madam Chair, thank you. I am ready, and I'm just making sure I'm virtually certain that I see my testify, at least one testifier on, I believe the on the line as well. So yeah, I think we're ready to go.
All right, and of course, as soon as I said that, Representative Olson joined the Zoom. So put that on pause, Representative Pinto, and we'll stick with the order. So we have Representative Olson's bill. I know that you're co-presenting this with Representative Baker. I know I saw him on earlier, so I will move House File 4265 be referred to Ways and Means. And with that, I will turn it over to Representative Olson and Representative Baker. So Representative Olson.
Thank you, Madam Chair, and thanks for your flexibility during this time of year and multiple bills in multiple places. So thank you, Madam Chair. And so I'm glad to be co-presenting this with Representative Baker, and those that were in the legislature in 2019 might remember the work we did on the opioid legislation, in which we did a lot of work around opioids. And one of the things we knew at the time was that we'd be likely seeing some lawsuits and potentially settlements or funds coming from those lawsuits into the state of Minnesota, but we couldn't fully anticipate what that would look like. And so there's some changes that need to be made to the legislation that we passed then. And so Representative Baker and I have been working with the Senate authors of that original legislation to make sure that we honor that and really just do what we need to do to unlock this national opioid settlement money, which we're going to talk about more. So last summer, Minnesota signed on to the national opioid settlement, and Minnesota is expected to receive nearly $300 million. And the complex settlement requires states to come to agreement with local governments on certain terms. And so the Office of Collaboration and Dispute Resolution convened various stakeholders, including the Association of Minnesota Counties, the League of Minnesota Cities, the Coalition of Greater Minnesota Cities, the State of Minnesota, and the Attorney General's Office, who worked together to reach an agreement on funding distribution. The agreement calls for counties and cities to receive 75% of settlement funds and 25% to go to the state. Coming out of the stakeholders process, the OCDR and the Office of the Attorney General approached legislators with several needed legislative changes, which are reflected in House File 4265. These include implementing the 75-25 split, releasing the funds. So current law specifies that settlements funds must be deposited in a separate account in the state treasury, and funds only go into the opioid funds once the Board of Pharmacy fees sunset. So House File 4265 makes a change to get these funds out and in use combating the crisis. And it also implements the necessary change around the claims bar, which I think is most within your jurisdiction here, of maximizing how much settlement money Minnesota receives requires barring subdivisions remaining legal claims against the opioid companies. And so House File 4265 makes all these necessary changes in order to fully capture and maximize and get out the door the opioid settlement funds. And with that, Representative Baker will explain a little bit more, and then we also have the Attorney General here to speak in more detail about the settlement. So Representative Baker would be next.
All right, Representative Baker.
And Madam Chair, thank you, and members. again, really proud to carry this this House File 400 2.0, and it's not the number today, but that was a real nation-leading bill that we really took a couple of years to get over the finish line, to get the pharmaceutical companies to get us to come along with some licensing reform that we did. Along that, we did know that we were going to see some lawsuits sometime down the road, and part of that language was when do we sunset back to once we know when the lawsuit money will be reached in Minnesota. We've got that cleaned up in this bill here too. But again, to Representative Olson's point is tonight your jurisdiction needs to talk about the claims and the releasing of those claims for the distributors and Johnson & Johnson as part of this lawsuit. So again, I have been working really closely with the Attorney General's office for the last 3, 4, 5 months. It's been an exhaustive process, but we had to get this right. And again, we've had the counties and the cities really kind of 100% of them have really endorsed this from the cities and counties level. And so with the AG's office to help us sort of walk through the final details of this, which I know is really important to this committee, we're looking forward to carrying this to the finish line again to kind of make sure that we're ready to receive these lawsuit dollars and put in the good work. And a largely part of my ORAC work, which is the Opioid Epidemic Response Council that I serve on, I'm happy to try to make sure that we get these funds to that council and we can use them around the state of Minnesota as best we can. So with that, Madam Chair, I'm just here to really lean into my support into this bill. I know that it's moving very well in the Senate right now. Senator Rosen and Eaton are carrying the bill, and again, we're keeping in contact with them as well. So with that, Madam Chair, I'll turn it back over to the AG's office. Thank you.
All right. And before we go to the Attorney General, I just want to recognize both Representative Olson and Representative Baker. For members who were not here in 2019, the amount of work the two of you have put in to dealing with this opioid problem and what we're going to do here in Minnesota, it's one of the biggest things we've passed in my time in office, and just really appreciate the work of both of you. We'll now turn it over to Keith Ellison. Please go ahead, Attorney General.
Well, yeah, this is Keith Ellison, Attorney General, and I want to say thank you to you, Madam Chair Becker-Finn, and Vice Chair Moeller, and Representative Scott, our ranking member, and all members. And I have to join you. Representatives Olson and Baker have done just nothing short of excellent work. It's a pleasure to work with both of them. It's an honor to partner with these two wonderful public servants. But let me begin with the numbers. And I think it's important to begin every conversation with the human reality here. In Minnesota, we've had 5,500 people who've lost their lives to the crisis since the year 2000. Things have not gotten better. Actually, in 2020 was one of the worst years, where we experienced 678 deaths alone in 2020. And the crisis hits every corner of our state: urban, suburban, exurban, small town, rural. Nobody's immune. But those are the numbers. The truth is, this is happening to people, happening to families, as you know. You know, a woman in Arden Hills who I got to talk to and meet, she told me that in 2012, her mom was prescribed a small amount of opioids to relieve her back pain and additional opioids after surgery to remove a cancerous tumor. She quickly built up a tolerance and became addicted and needed to take more and more opioids to achieve any pain relief. She suffered with this addiction for years before overdosing on morphine in 2015. Another woman who I met in northern Minnesota told me about her husband, an Army sergeant, heavy-duty truck mechanic. And after being injured on the job, he was given Oxycontin to handle the pain. She told me his doctors prescribed it like it was candy, and he quickly became addicted. Eventually, his doctors took him off the opioids entirely without any slow tapering. He suffered devastating withdrawal and ended up dying by suicide. So there's no amount of money that could ever make up for the death and destruction that opioid companies have caused in Minnesota. The value of even one life lost is incalculable. And I have to take my hat off and salute and honor those families who may have lost a loved one, but despite their grief, carry on in an effort to try to protect other families from suffering that same grief. And I'm so in honor of those people. We must hold these companies accountable, and we have been holding them accountable. We've now reached 5 different settlements, 5 different multi-state, multi-million-dollar settlements with opioid companies. The largest of them are the settlements with the manufacturer Johnson & Johnson and distributors AmerisourceBergen. That's one company. Cardinal Health, McKesson, that we reached last summer. And these 2 different settlements just bring in about almost nearly $300 million to Minnesota over the next 18 years. The money will be front-loaded, so we'll get more of the money up front. As part of turning these settlements into reality, part of my office worked with Representative Baker and Ellison and others, as well as counties and cities, in a process last fall of convening stakeholders from state and local governments to determine how to allocate the money. It's needed everywhere. My principle was the money has to go where the pain is. All these groups together, counties and cities, unanimously agreed to allocate 75% of the money to local units of government and 25% to the state, the overwhelming majority of which will be spent on abatement, treatment, remediation, and prevention. And I'm pleased that all 87 counties and more than 140 cities have voted to adopt and approve this allocation. Wisely, in 2019, before any of the settlements with opioid companies had been reached, the legislature, you all, passed an important piece of bipartisan legislation called the Opioid Epidemic Response Bill. That law specifically dedicated opioid settlement funds to opioid abatement rather than transferring them to the general fund. Very wise, forward thinking. Congratulate yourselves. It also established the Opioid Epidemic Response Advisory Council, ORAC, to oversee the spending of the state's share of the money. Thank you for your foresight in doing so. Now, as a final step, House File 4265 will enact changes to that 2019 statute that were needed so that Minnesota can receive the maximum possible share of these settlements, and the $300 million can flow to Minnesota communities all over the state where it's desperately needed. I'm asking you to support it. Again, I have to thank Liz Olson and Dave Baker for the wonderful work they have done, for their diligence, close partnership, and seeing the work right through to the finish. It's true public service. And I'm certain that every member of the House, without exception, recognizes how Representative Baker has turned the terrible tragedy and loss of his son in the opioid crisis into true relief and hope for families and communities around Minnesota. Thank you for that, sir. Now I'd like to ask some folks from my office, if it's okay, to give some of the greater details. I would submit to you that there are no 2 people in the state of Minnesota more versed in the topic than these staff members of mine, Evan Romanoff and Eric Mahoney. Madam Chair.
Yep, thank you. I have Evan Romanoff on the list and then a couple other people on hand if there are additional questions. So Mr. Romanoff, I will go to you. Please introduce yourself and go ahead with your testimony.
Thank you. Good evening, Chair Becker-Finn and members of the committee. I'm Evan Romanoff, and I'm one of the Assistant Attorneys General who was assigned these opioids-related matters back in 2016 under Attorney General Lori Swanson. Thank you for the opportunity to be here today, and thank you especially to the bill authors, Representative Olson, as well as Representatives Baker, Cagle, and Chair Becker-Finn for all your incredible work and leadership on this issue. As Attorney General Ellison stated, last summer, the state joined nationwide settlements with 4 companies, which were really the culmination of a years-long multi-state investigation into them stemming from their actions that fueled the opioid epidemic nationwide. In addition to injunctive relief, the settlements provide for potentially more than $300 million to the state. They resolve claims not only of states, but also of thousands of participating cities and counties nationwide. The financial structure of the settlements provides that the more cities and counties that join the settlements, the more money the state receives, as well as the cities and counties. So accordingly, the settlements are designed to incentivize cities and counties to join and incentivize states to also encourage those cities and counties to join. They're uniquely structured, these settlements are, in that they allow individual states to come up with our own agreements with local governments to determine how the funds should be allocated and spent within the state. So our office has worked over the last several months with the Association of Minnesota Counties, the League of Minnesota Cities, the Coalition of Greater Minnesota Cities, the Minnesota Indian Affairs Council, MDH, DHS, MMB, members of the legislature, state and local public health officials, and healthcare providers. And after many months of these meetings, which were facilitated by the Office of Collaboration and Dispute Resolution, we reached the agreement that Attorney General Ellison mentioned, that local governments will receive 75% of the settlement funds directly, cities and counties, and 25% will go to the state to be overseen by ORAC, by Representative Baker's council. The agreement also identifies a 13-page non-exclusive list of approved opioid abatement programs and strategies for which the state and cities and counties can dedicate funding. So as AG Ellison mentioned, all 87 counties and over 140 cities have signed on to the state-local agreement and joined the settlements, which is part of maximizing the amount of funds we'll receive. HF 4265 is a necessary step to implement this agreement and consists really of three main items. First, to release settlement funds to allow cities, the counties, and the state to put them to use right away in fighting the epidemic. Second, it will amend the statute to codify the agreed upon 75-25 state and local split. And then finally, it enacts a claims bar, which is needed to maximize the amount of funding we will receive from the multi-state settlements. Thank you, and me and my colleagues are happy to answer any questions you might have about the settlements.
All right, so you were the only one that was on the list to testify. I think everyone else was here on hand in case there are questions, so we will move on to member discussion. Representative Scott. I know she was having some technical difficulties, so we'll give you a minute.
Thank you, Madam Chair. I had an update to my computer today, and now my Zoom doesn't work. And of course, it happens
to all of us at some point. My Teams doesn't work on my computer anymore. So go ahead, Representative Scott.
Thank you, Madam Chair. And while we have the Attorney General here, I did want to just join him in saying how much I appreciate all the work done on this topic over the years with Representative Olson and Baker. And I do really just kind of have more of I do have a question for the Attorney General. And that is, as our state's chief law enforcement officer, we see a lot of illegal, fentanyl, all sorts of illegal drugs coming across our southern border, some of them opioids. And I'm wondering if he's had any conversations with the White House to address closing down the southern border so this stuff doesn't continue to come up and make a toxic environment for our country and lead to many more deaths like the ones that the Attorney General spoke of in his earlier testimony.
Well, I appreciate you trying to take advantage of us having the Attorney General here, as has been the case all day and all year. That's not really before us and isn't really related to the settlement bill. So because we've got a full agenda today, I encourage you to reach out to the Attorney General offline to have a discussion about that. We've really got to stick to the agenda today. But appreciate you bringing it up, but we're going to stick to this bill. The question before us today is whether we're going to move forward on this bill that Representative Olson and Representative Baker have presented. Representative Scott, any questions to the bill?
No, thank you.
All right. Any further member discussion? All right. Seeing none, Representative Olson and Representative Baker, any closing comments?
Thank you, Chair Becker-Finn, and thank you, committee members, for hearing this bill. And I'll just echo too, it's always a delight to work with Representative Baker. He's a great partner in this and carries a lot of the weight in the water on this. And the Attorney General himself, as well as his staff, have just been fantastic in this. At times is a very technical bill, and at times it's much more than that. And to manage all of that has been really important. And so just thank you for this hearing, and thank you to everybody who's done work, and just ask for your support on it.
All right. Thank you, Representative Olson and Representative Baker, and to everyone who's worked on a bill that's much bigger than anything we could cover in just this hearing. With that, I will renew my motion that House File 4265 be referred to Ways and Means. The clerk will take the roll.
Becker Finn,
Aye.
Mueller,
Aye.
Scott,
Aye.
Feist,
Aye.
Frazier,
Aye.
Rossel,
Aye.
Herb, Representative Herb, Hollins. Oh.
Aye.
Hollins,
Aye.
Johnson,
Aye.
Liebling, Representative Liebling, Long,
Aye.
Mortensen,
Aye.
Novotny,
Body aye.
Barr,
Or aye.
Robbins,
Aye.
Vang,
Aye.
Zhang.
Aye.
That is 16 ayes and 0 nays.
All right, the motion prevails. And oh, you see Representative Liebling is on. Did you get your vote in?
No, aye.
All right, 17 ayes. The motion prevails and the bill is on its way to Ways and Means. Thank you, Representative Olson and Representative Baker. Moving right along now, Representative Pinto, hopefully you're still on. Representative Pinto, I will move House File 4174. I believe it's your desire as the chief author that you'd like this bill laid over. Is that the right motion, or do I need to send it elsewhere, Representative Pinto?
I think that is the plan, Madam Chair.
All right. So I will move House File 4174 in front of us. And then I understand you have the DE4 amendment. So I will move the DE4, and I'm assuming that's an author's amendment. It's a DE. So if you want to say anything to the amendment, Representative Pinto.
I'll just say that the bill's the result of a lot of work, and that has continued. And so I appreciate members putting the bill in the form that we wish, and we can then describe it.
Sounds great. All right. Any further discussion to the DE4? All those in favor, please say aye.
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 Opposed? All right. The motion prevails. The DE4 is amended. Representative Pinto, please tell us about your bill as amended.
Thank you so much, Madam Chair. Members, good to be with you tonight. So House File 4174 is a bill that addresses the intersection of two legal doctrines. Each one of them causes somebody to be liable for a crime that they did not themselves commit. And when you combine those two doctrines, where each one of them individually sets that up, it can set up some real problems to then have people have both those doctrines apply. That sounds very legalistic and technical. In just a minute, we're going to hear about the impact of that on people's real lives. I want to have members just be aware of kind of the background here, that last spring, we established a task force to examine these issues. One is aiding and abetting liability for crimes, and the other is the crime called felony murder. We appointed a task force to examine the intersection between those two things. That task force met in the summer and the fall and into this year, and came back with unanimous recommendations that are reflected in the bill before you. Those recommendations include that we should limit this doctrine of aiding and abetting felony murder to certain situations where the person involved has a strong culpability for a death, and to emphasize that these are situations where someone has died, and we want to make sure that there's people are held liable for that, and we want to make sure that people are held liable for things that they themselves actually did. And so Section 1 of the bill has that limitation to say that people who are charged with these crimes should have that strong connection with the crime. Section 2 of the bill, which you'll note is substantially longer, addresses what we do about people who have already been convicted in the past in what we will have determined in Section 1 to be an unfair way. And so there's a lot of work that's gone into that. I need to give a big shout out now, and probably will again, to Representative Mueller, member of this committee, who's worked incredibly hard in putting this together. We're really proud of what we put together to make this work, to have a retroactive application, and to have people not be held in custody any longer than they would need to for crimes, again, that they did not commit. And then Section 3 of the bill would continue the task force to continue to examine some needs in this area. I guess that's Sections 3 and 4, pardon me. Madam Chair, members, I have two testifiers, someone who described her own experience relating to this, and a law enforcement representative as well. And so I'd ask to move to them if we can.
All right, thank you, Representative Pinto. First up, I have Tony Cater. Please introduce yourself for the record and go ahead with your testimony.
Good evening, Chair and Representatives. My name is Tony Cater, and I'm the co-founder of FMLR and the mother of Megan, an impacted person under aiding and abetting felony murder laws. We began our journey into understanding the aiding and abetting felony murder laws when Megan, my daughter, and her best friend, Brianna, were 19 and 20 at the time of their tragedy. They both had been raped in high school and were suffering self-medicating those traumas during this time. After Brianna's prescription medication was stolen by their friend, a young couple who also sold them drugs, Megan and Brianna wanted to go and get it back. A male friend from high school had been this young man's roommate and had also had some items stolen. He reached out to Megan to share that he and a friend were going to get his items back. So the 4 19 and 20-year-old kids made the decision to go together. One thing led to another, and one of those young men decided to bring a friend, and that friend brought his 33-year-old uncle who brought a gun. The girls ended up having their lives threatened that night by this man, being told if they screwed anything up, they would be killed, and then forced to lie on the floor of the apartment and watch their friend beaten and then shot. The girls were and still are terrorized by the memories of this horrific night. They both suffer from constant nightmares. Their hearts and our hearts go out to the family of the young man who lost his life that night. The girls could never have imagined what was going to happen. Megan and Brianna, the 2 young men who never left the car, and the 2 men who beat and then murdered this young man, all received the exact same charges of first-degree murder. What we now know is this is not uncommon. Megan is now 24 and over 4 years into her prison sentence. Megan and Brianna continue to amaze me as they take correspondence college courses, educate themselves on trauma reduction, mentor the women around them, pray and host Bible studies, all while surviving the current COVID protocol, which has only allowed us a handful of visits in the 2 years. These 2 young women continue to have hope in the system, in their faith, and hope in you, their lawmakers. As you had just heard, we had a legislative ordered bipartisan task force made up of county attorneys, police representatives, public defenders, victims' rights organization, impacted family members, law professors, civil rights organizations, and others. It was a well-rounded group of stakeholders brought together and charged to look into the laws, charging, and sentencing practices, the national practices and changes, statistical data, and bring back recommendations if changes were needed. I was appointed to the task force as an impacted family member and chaired the outreach subcommittee. On 2 occasions, our task force had opportunity to listen to men and women within the DOC who are currently serving sentences under these laws. These days were very impactful for all. We had robust conversations in our task force and spent months looking at the 3 focused areas of data, laws, and case law, and outreach to both victims and impacted persons. What we brought back was a unanimous report. What stood out most to me from the time on the task force were the disparities in sentencing, disparities by county, by age, and most glaringly by race. 64% of those convicted are persons of color. I believe HF 4174, the bill here tonight, has been worked on by a large group of stakeholders. I want to thank Representative Muller and Pinto for their work and the constant hours put into this. I believe this reform will align with the task force recommendations and will promote public safety and justice at the same time. It will also allow those wrongly convicted for crimes of another to be resentenced to the crimes they did commit, and eventually to come home to their families, to be active in our communities, good neighbors, tax-paying working individuals. Minnesota is not safer with Brianna and Megan in prison, nor is it safer with Crystal or Louise or Maureen, nor the many others who are locked up for extensively long sentences for crimes they didn't commit. I am here today as an impacted mother and the co-founder of FMLR, and I'm asking for your support in moving this bill forward. Thank you.
Thank you for your testimony, and thank you for sharing that story. I know that it's difficult to provide testimony in a public setting like this, and I know that there's a price that the grief takes a toll, and so I appreciate you sharing with us today. The other testifier I have on our agenda is Chief of Police Brian Mueller. Chief Mueller, if you could introduce yourself and go ahead with your testimony, please.
Thank you, and good evening, Madam Chair, committee members. My name is Brian Mueller, and I'm the Chief of Police for the City of Stillwater. I'm a member of the Task Force Rating and Abetting Felony Murder. I've been appointed jointly by the Minnesota Chiefs of Police Association as well as Minnesota Sheriff's Association. I'm also former chair of the Violent Crime Coordinating Council, which oversees all of our violent crime enforcement teams. What I want to stress more this evening than anything else is that this proposed reform to limit liability for aiding and abetting felony murder will not negatively affect public safety. It would in fact enhance public safety. Looking at the issues through a law enforcement lens, I have to admit initially I was skeptical. As a police chief, I understand that homicides are some of the most serious offenses that we see, having rippling effects throughout the community. There's no duty we hold more sacred than our duty to protect the individuals we serve from loss of life. During my time on the task force, I heard stories from people affected, much like Ms. Cater. We studied the data and engaged in open, productive discussion with other task force members. What is clear is that an inconsequential actor's involvement in a death does not impact public safety in the same way that those immediately related to that homicide do. In law enforcement, we protect the public by concentrating our efforts on the most factually culpable actors, while seeing to it that others who may have lesser involvement are still processed accordingly. That is exactly what this bill will allow us to do. To be clear, we are not talking about someone who actually pulls the trigger of a gun used in a murder, but rather individuals that by proximity, relationship, or initial involvement in a lesser crime that are involved. Many of these individuals happen to be women taken advantage of and not having any direct knowledge of the intention of murder. When our task force submitted its final report, I was proud to add my law enforcement voice to the unanimous agreement of the principles this bill aims to advance. Proportionate punishment does promote public safety. The reform the task force recommended, which is incorporated into this bill, will make our streets safer. Madam Chair and Committee, thank you for allowing me time to testify this evening.
Thank you very much for your testimony, and thank you to both of you for serving on the committee. And it sounds like Chief Mueller, you've put in plenty of hours serving on all kinds of public committees and task forces, and really appreciate that part of your service as well. So thank you for testifying tonight. I don't have any other testifiers on the list, so we will move on to discussion. Representative Novotny.
Thank you, Chair Becker, and I haven't had a chance to speak with Representative Pinto about this, and I still have the questions about some of the language and the threshold that they have, the major participant and extreme indifference. But I'll ask you a different question related to that. With the current language that we have, isn't there discretion for attorneys in the charging documents that they could address this? And there's lots of discretion has been shown in charging. Why are the attorneys creating this situation to start with?
Representative Pinto.
Thank you, Madam Chair. Thank you, Representative Novotny. It's true there's a fair amount of discretion. I'll note that sometimes there's been some criticism directed to prosecutors who exercise a fair amount of discretion. I'll note that I, as a prosecutor, when I'm assessing a case, the core responsibility is due justice. And so certainly, that means a fair amount of discretion in that. I will note, though, that I take extremely seriously in my role as a prosecutor. And I should note, Madam Chair, are you able to hear me? I saw a little note, internet connection unstable.
I'm able to hear you, but you might want to turn off your video. Your audio was fine. There you go.
Okay. Okay, good. I'm hoping that'll work. My apologies. So Representative Novotny, I take very seriously my responsibility as a prosecutor, even in exercising that discretion, to take into account the legislature. We are the ones who set statutes. It's our job as prosecutors to listen to the legislative branch. And if the legislative branch says someone who aids and abets a felony and then the felony results in a murder, even if the person in the first case had nothing to do with the murder, boy, I should, as a prosecutor, and I would think that you would want me as a prosecutor to, in general, be charging those cases, because that's the way the statute's written. And if we as legislators don't like that, we should change the statute, which is, of course, what we're proposing to do here. So yeah, there is some discretion, but I think we probably all want to be cautious about encouraging prosecutors, and I kind of feel like I've heard that from you and some of your colleagues as well, to simply not charge cases when the statute is written in a way that say they should be charged.
It's almost like making prosecutorial decisions is really hard sometimes. Further questions, Representative Novotny.
It'll be more of a comment, Chair. There's discretion from the day you sit down to draft your request for a long form complaint, as several of us have done many times. There's discretion in when that long form complaint is drawn up. There's discretion when you go to negotiations for court, discretion with the judge, and there's discretion in sentencing already. Thank you, Chair. Thank you, Representative Pinto.
Thank you. Representative Johnson.
Chair Becker-Finn, Representative Pinto, and to the testifiers. I understand what's going on here, and some of it I agree with. One problem that I still have with this bill is the lack of definition. You have one of them is major participant. In public safety, I was told it would be left to the judge to decide. As you stated, we write the legislations, and in legislation, we have definitions. And I think terms like major participant is something that needs to be defined. Is a major participant somebody that hired somebody to go do something and they went beyond what they were hired to do? If they hadn't been hired to go shake somebody down, the homicide might not have occurred. Is a major participant somebody that's asked to drive the getaway car at the bank, where the security guard ends up trying to stop the bank robbery and is shot and killed? We need to make sure that we have the definitions in place to provide guidance for the prosecutors. You've talked about prosecutor discretion. We now have prosecutors that are refusing laws to charge laws that we have on the books. So if we're going to do this, we need to make sure we do it right. And some of these definitions need to be put in statute. And until that happens, I cannot support this bill.
All right, Representative Vice Chair Moeller.
Thank you, Madam Chair. And I think that Representative Pinto will be able to answer specifically some of those examples of major participant. But I just want to say that as somebody who frequently practices in appellate courts and deals with statutory interpretation, not every word is defined and not every concept is defined in statute. And one of the great things is we have principles of statutory interpretation. And sometimes when something isn't defined, courts will listen actually to our audio from these hearings, and that will assist them in figuring that out. And so I think it's going to be really useful for Representative Pinto, for the record and in response to Representative Johnson's question, to go through what we're actually talking about when we're talking about major participant. And in my opinion, it isn't necessary to define that in statute. Thank you.
Thank you. My adjunct law professor self thanks you for bringing that up, Vice Chair Moeller. Any response, Representative Pinto?
Thank you, Madam Chair. And please, Madam Chair, alert me again if I'm getting an unstable connection here. But I'll just note that in another state that has this very same legal setup that we're describing here, I'm looking at the jury instructions in that state, which is how this applies. And it says, that directs the jury, when you decide whether the defendant was a major participant, you should consider a number of factors such as the following. What was the defendant's role in planning the crime that led to the deaths? What was the defendant's role in supplying or using lethal weapons, if any? What did the defendant know about dangers posed by the crime, et cetera? Was the defendant in a position to facilitate or prevent the death? And there's a series of questions. So this is not sort of a general undefined thing. This is something where there is case law and there's a structure in place. And this is how we as prosecutors would do this, because I'll note that we as prosecutors would still need to bring this forward. But if the idea is that we would simply look at this and, well, back to the point about not charge something in the first place when the law says that we should, well, as I say, I think that there's been some criticism of that. If the statute says this is what we charge, then in general, we're going to charge it. Thanks.
Thank you. Moving on, Representative Hurt.
Thank you, Chair Becker-Finn. And I just wanted to I just had a comment. I just wanted to thank Representative Pinto and all those who worked on this particular bill. I'm listening to the conversation and I just wanted to point out that, discretion and that people are given discretion and the system is set up that way. We as people of color and women and those who are from trans LGBTQ communities that, when there's discretion always actually hurts usually hurts us. It doesn't benefit us and it doesn't favor our situations or our experiences. And we know that in the justice system that the statistics around the fairness of our experiences within the system shows that we are not treated the same. We're not given the same leniency or the same types of consideration. And so I really appreciate Representative Pinto's effort in this bill to codify this information and this into law so that we do have a system that people are working off of language that is defined. So I just wanted to say thank you to Representative Pinto for doing this.
Thank you. Finally, Representative Scott.
Thank you, Madam Chair. And I have many things that I could and want to say, but I'll just limit it to the fact that this is the Judiciary Finance Committee, and I haven't seen a fiscal note on this bill. Is there one? Has one been asked for? And if so, when might we see one?
Representative Pinto and I will also let you know that we're laying this over, if that's helpful. Representative Pinto.
Thank you, Madam Chair, and thank you so much, Lead Scott. As I referenced in bringing up the DE4, this has been quite a process in pulling this together. And so I'm virtually certain that the fiscal note request is in, but we've been, continually making it work in terms of the structure and feeling very good about it. But as you say, we're still awaiting that, and that's certainly a good reason for it to be laid over today. Thank you.
Yep, and I just checked with staff, and the fiscal note has been requested. We don't have it yet, and when the language changes, that always can change things too. So, further questions to the bill, Representative Scott?
No, thanks, Madam Chair.
All right. Seeing no further hands up, any closing comments, Representative Pinto?
Thank you so much, Madam Chair and members. And I'll just note that, at a gut level, right, we're talking about situations where people are being held liable for crimes that they did not personally commit. There are situations under our law where that applies, but those, I would think that all of us across the ideological spectrum, those of us who believe in limited government, et cetera, would say that we should be keeping those to be a bare minimum. And we should not, by the way, vest it in certain people to decide really broadly with discretion about whether or not they're going to bring charges in certain cases or in others. I thought Representative Hurst's comments were so well placed on that. Members, once we've made the decision that someone should be held liable for the crimes that they themselves have committed, then we look back and say, and then somebody should not be held in custody any longer if in fact that applies to their situation. That's what the bill does. And I think we should listen to our unanimous recommendation of police, prosecutors, and impacted people from a variety of perspectives who are urging us to pass this. Thank you so much, Madam Chair and members. Thank you.
All right. Thank you, Representative Pinto. With that, House File 4174 as amended is laid over for possible inclusion in an omnibus bill. Thank you, Representative Pinto, and thank you again to our testifiers for sharing your perspectives on this somewhat difficult topic. With that, members, we are going to move on to the next bill. We've got House File 3398. Representative Hollins, would you like to move House File 3398 be referred to the General Register?
Thank you, Madam Chair. Yes, that is my motion.
All right. And Representative Hollins, would you also like to move the DE1 amendment?
I would. Yes, Madam Chair. That is my motion as well.
All right. The DE1, I believe, is an author's amendment. Representative Hollins moves the author's amendment to get the bill in the shape she would like. Any discussion to the amendment? All right. All those in favor, please say aye.
Aye.
Opposed? All right. The motion prevails and the bill is amended. Representative Hollins, to your bill as amended.
Thank you so much, Madam Chair, and thank you, committee members. House File 3398 is legislation to ban no-knock warrants in Minnesota. I'm here today asking for support for this bill after spending countless hours with advocates, community members, fellow legislators, and law enforcement. Research shows that no-knock warrants are dangerous to civilians and law enforcement alike. Data collected has shown that no-knock warrants have led to the death of at least 82 citizens and 13 police officers between 2010 and 2016. In addition to that, 40 innocent bystanders have been killed by no-knock warrants since the early 80s. No-knock warrants also can conflict with Second Amendment rights. And furthermore, the National Tactical Officers Association, which is kind of like the National SWAT Association, has acknowledged that, and I quote, no-knock search warrants, though well-intended, no longer pass the test of tactical science, risk mitigation practices, and liability-conscious decision-making. We're bringing this bill forward in Amir Locke's memory, in Breonna Taylor's memory, so that no more families have to grieve for people who died because we didn't do enough. Minnesota would not be the first state that has banned or strongly restricted these types of warrants. In fact, Florida has banned them since 1994. 4 states and many municipalities in the country have also ceased using no-knock warrants, and they have continued policing effectively. The vast majority of law enforcement officers in our state do not use no-knock warrants regularly, further indicating that policing without no-knock warrants is absolutely possible. Minnesota has a no-knock warrant problem, and we're here to fix it. This is our opportunity. I am joined today by a number of fabulous testifiers, and I want to thank them all for being here and taking the time to do this. I hope that the committee will accept their testimony with an open heart, and I'll turn it over to them, Madam Chair.
Great. Thank you, Representative Hollins. The first person I have on my list is Jerome Treadwell. Please introduce yourself for the record and go ahead with your testimony. Maybe he's not on. We'll go to the next person on the list, Michelle Gross. And I will remind members and our testifiers, out of respect for all of the other testifiers, we're going to limit everybody to 2 minutes apiece. I know that we have tried to communicate that as well as we could ahead of time, but we'll move on to Michelle Gross.
Thank you, Chair Becker-Finn and members. My name is Michelle Gross, and I'm the president of Communities United Against Police Brutality. We're an organization that works for police accountability and for professional constitutional policing. And I'm here, of course, today to talk about no-knock warrants. No-knock warrants are a relic of Nixon's failed war on drugs. That time period led to the development of the kind of militarized policing that is constitutionally questionable and has driven a wedge between law enforcement and the community. Since that time, many things have changed. In particular, legal gun ownership has increased substantially. At this point, 42.8% of households in Minnesota have at least one legally owned firearm. The Fourth Amendment makes it clear that we have a constitutional right to the highest level of privacy in our homes. And further, the Castle Doctrine outlines the right to defend ourselves in our homes. Thus, the mere presence of a firearm in the home can no longer be justification for a no-knock warrant. No-knock warrants along the way should have been a tactic of last resort and thus exceedingly rare. However, data collected as a result of last year's legislation shows they aren't. Data collection just started in September, and since agencies have 3 months to report this information, the data are incomplete. Still, since September, a report by the BCA shows that Minnesota courts signed 71 no-knock warrant applications. Of these, 49 were actually executed as no-knock warrants. Further, the limited data show a racially disparate impact of no-knock warrants. While Black people are 7% of our state's population, they were the subjects of 70% of no-knock warrants executed in those few months. Most no-knock warrants were for weapons or drug-related offenses, but have been used to search for things like stolen gift cards and even a stolen puppy. We attempted last session to put some guardrails around no-knock warrants, but even those modest efforts were resisted. House File 3398 addresses the deficiencies in last year's legislation and will strengthen the legislation to the point that we should have no further deaths from no-knock warrants. I'm going to limit my comments there, but I'll make myself available for any questions. Thank you.
Thank you very much for your testimony. Next on the list, I have Carlotta Madison. Carlotta, if you could introduce yourself for the record and go ahead with your testimony, please.
Okay. Hello, everyone. I'm trying to turn my camera on. 1 second. Okay.
There you go.
Okay, yes. I'm here today to testify because, well, my name is Carlotta Madison, and I'm here because my brother, Andre Madison, was a victim of a no-knock warrant. When the police came to a duplex where he was visiting, he thought the place was being burglarized because they threw a flash grenade in the back door. And so he had grabbed a shotgun. And then when the police tried to force their way in the front door, they thought they were being fired upon because of the flash grenade. So the police start shooting at each other. The police officers in the back were shooting, the police officers in the front were shooting. My brother took cover. Unfortunately, over 500 rounds of gunfire went off, and he was hit twice, once in the neck and once in the arm. There was also an officer hit in the neck, Officer Lananza, and he was hit by police gunfire as well. They called it friendly fire at that time. Meanwhile, while all this chaos is going on, there's a woman upstairs in the upper duplex putting her children in the bathtub and covering them so that the gunfire doesn't hit them as well. After all the chaos stopped, then they were able to go in and see the victims. One was my brother and another one was an officer that was hit by friendly gunfire. And I'm saying that because the element of surprise just didn't work. And a lot of times it doesn't. And my brother ended up dying because later he didn't have the organs he needed because of the gunshots he got during that time. And it was just over something very simple, and there was no way that whatever they were looking for, and I don't, what they were looking for, they didn't find anything. My brother had never had a criminal record before. And so it just seems like that was 25 years ago. And here we are still talking about no-knock warrants. And that's what I wanted to say today.
Thank you very much for your testimony. I have been notified that Jerome Treadwell is with us now. Mr. Treadwell, if you could introduce yourself and go ahead with your testimony.
Hello, everyone. Can y'all hear me well?
Yep, loud and clear. Please go ahead.
Wonderful. My name is Jerome Treadwell. I'm a senior at Highland Park High School. I'm 17 years old. I'm the executive director of Minnesota Teen Activists and also the youth president of the St. Paul chapter. Today, I'm here to share with you all in a brief time the importance of banning no-knock warrants and the immense internal damage it has caused within the Black and Brown community. It's a shame that Black and Brown girls have to worry about, will they be busted in if it's the wrong victim as they're asleep on the couch with a blanket over them? On Tuesday, February 8th, thousands of students, Black, Brown, White, Asian, Hispanic, you name it, walked out of class and gathered in the Twin Cities of St. Paul, Minnesota, because we don't feel safe. We are living in the Jim Crow of the North. This is modern day lynching. It's one thing to racial slur, impede your racial stereotypes, but when you begin to take the lives and murder Black children, everything has to stop. You cannot rob children of their future hopes and dreams. You cannot take away the lives of innocent people. I'm here today because our lives have been stolen. But today we signify no-knock warrants. We don't need another Breonna Taylor. We don't need another Amir Locke. And we certainly don't need another victim who we don't hear about. And not just Minneapolis and St. Paul, but Duluth, Big Lake, Rochester, and other cities throughout Minnesota. This no-knock warrant bill has to be implemented all throughout the state of Minnesota. So we must pass this bill. It could have been me. The very fact that there are other students sleeping at night who risk their lives. And it's challenging to me that we still do not accept and understand that we must pass this bill. Partly because innocent convictions, innocent murders, because of the color of your skin. Consistently, we have experienced these tragedies by the hands of police. But today I give you the opportunity to be under the blanket with Amir Locke. Let us sit in a moment of silence for 9 seconds, the 9 seconds that marked Amir Locke was executed by Minneapolis police. In just that time, Amir Locke was murdered. No chance at all. We've seen Emmett Till. We've seen so many victims connecting our past to the present. And the very fact that we're here today, Amir Locke should have been 22 years old this year. So he is a young body. He is a young life that I'm standing in advocacy for as a 17-year-old, not too much younger than him. So today I stress the importance that we move away from the Jim Crow of the North and we put emphasis on protecting young Black lives. Thank you.
Thank you for your testimony. Next on the list, I have Jonathan McClellan. Please introduce yourself and go ahead with your testimony.
Hello, my name is Jonathan McClellan, and I'm president of the Minnesota Justice Coalition. I would like to thank Representative Athena Hollins for carrying this common sense piece of legislation that will reform no-knock search warrant law by protecting the community and public servants alike with best practices. In 2012, when I was serving on duty as a Minneapolis firefighter, I received a call from my children saying the police were at my home. The police were getting ready to serve a warrant for an individual who used the address sometime in the past before I purchased the home. The police came inside my house and my kids were scared. Once the police officers realized that the person they were looking for did not live there, they left. I found out the next day that the warrant was for a person on probation subject to a probation violation, and the address on the warrant was not the address the probation office had. I asked if law enforcement ever verified the name and address with the probation office, and I was told no. This was a situation where one of my kids could have lost their life on a warrant with misinformation. Law enforcement did apologize, but apologies do not correct the problem. Legislation does. Minnesota Statute Chapter 626.14 Subdivision 3 are the requirements for no-knock search warrant. There are 4 main steps that need to be taken to get a no-knock warrant here in the state of Minnesota. 1, a sworn affidavit that shows probable cause. The affidavit must include why a no-knock is needed as opposed to a knock and announce warrant. 2, what investigative activities have taken place to support the issuance of a no-knock search warrant. 3, whether the no-knock warrant can be executed during daylight hours. And 4, the chief law enforcement officer or their designee and a supervisor must review and approve the no-knock warrant. What a no-knock warrant in the current statute does not discuss or consider is innocent people that might be in their home, such as children, elderly or vulnerable individuals, the mental health concerns, cognitive or physical disabilities of people residing in the home. Last session, when we heard the no-knock legislation, I testified and used the Breonna Taylor case as one of my many examples of no-knocks gone bad. And it was stated that this ain't Kentucky. Here we are less than a year later from that testimony, and we are faced with the tragic loss of Amir Locke, who was 22. He was not the subject of the warrant that took his life in a no-knock warrant gone bad. This should send chills down our spine that a person could be shot in their homes while waking up from sleeping on the couch or laying in their bed. This is not a partisan issue. The tools we give police need to evolve, and we need to identify best practices and make policy changes for the greater good of all Minnesota. The Minnesota Justice Coalition supports House File 3398, and we ask that you do as well. Thank you.
Thank you for your testimony. Next on the list, I have Linda Sloan. Please introduce yourself and go ahead with your testimony.
Good evening, Chair Becker-Finn and committee members. My name is Linda Sloan, and I'm the Executive Director for the Council for Minnesotans of African Heritage. I am here to encourage you to support House File 3398 regarding banning no-knock warrants to improve public safety. First and foremost, a ban on no-knock warrants is needed to save innocent lives. Our police and public safety institutions and practices should function primarily to protect the innocent. Anytime we see practices that run counter to this primary public safety function, we have an obligation as public servants to do something about it. No one should have to live in fear of being killed by police entering their homes without warning. Secondly, a ban on no-knock warrants reflects emerging ideas about best practices in policing. House File 3398 follows best practices of other states and localities like Florida, Virginia, that have banned or placed strict requirements on no-knock warrants. And in fact, in St. Paul, police have not used a no-knock warrant since 2016. And recently, the city of Minneapolis has banned the practice. We should update our laws accordingly to follow this new public sentiment and value principle. Last, a ban on no-knock warrants would improve public safety in Minnesota. However, for this improvement to take place, we must move beyond the traditional militarized model that assumes a state of war between the community and law enforcement. That's just not true. No-knock warrants and the war model must be replaced by culture building, culture embracing, or institution building measures or strategies that bring community and law enforcement into alignment as mutual partners in creating public safety. One cannot exist without the other. In conclusion, show some compassion towards the community. One life taken is one life too many. Regain the trust of the people. Pass House File 3398. Thank you.
Thank you for your testimony. Next, I have Rob Dorr. Please introduce yourself and go ahead with your testimony.
Good evening, Madam Chair, members of the committee. My name is Rob Dorr, and I'm the Vice President of the Minnesota Gun Owners Caucus. I'm glad to be able to testify in this committee. I unfortunately missed the last committee stop because I was at Amir Locke's funeral while this bill was being considered, invited by his family there. And I was in the unfortunate position where I was trying to explain to them why the bill didn't ban no-knock warrants altogether. And some of the political realities, and I can tell you there wasn't much stomach for the political realities of the nature. And I think this bill is incredibly important for evaluation. The Minnesota Gun Owners Caucus supports evaluating the use of no-knock warrants because we're in a society where people have the right to keep and bear arms. There's a specific constitutionally enumerated right to defend your home with a firearm. And over 40%, as was just testified, of homes in Minnesota have a firearm in them, a lawfully possessed firearm. So on this other side of any door in Minnesota, of 40% of homes, there is a Minnesotan who is lawfully armed who may perceive a sudden, incoherently noisy intrusion into their home as a threat against their safety, and they would be lawfully able to use deadly force. That's just a terrible position to be putting our law enforcement officers in. Less than just a little over a mile away from my home is the home of Bianca Mathias, who last year had her home ransacked by the Anoka County Sheriff's Office off of information from Minneapolis with a no-knock warrant, and it was the wrong address. Van Kang, a few years ago in Minneapolis, shot a police officer when they had the wrong address during a no-knock warrant. One of the first things they teach you in law school, as the lawyers here will tell you, is the Blackstone's ratio, where it's better to let 10 innocent people go free than to let 10 guilty people go free than to let one innocent person suffer. Benjamin Franklin actually kicked it up by a factor of 10, where he said it's better to let 100 guilty people go free than to let one innocent suffer. We simply can't shrug off mistakes like this. And I hesitate because I don't want the legislature dictating tactics to law enforcement officers. When trying to keep communities safe, we want to make sure that law enforcement has every tool in the toolbox. But the legislature, in its duty to protect the rights of citizens, put very strict guidelines on the use of no-knock warrants, and they gave law enforcement an inch. Unfortunately, some agencies have routinely taken a mile, and we're left in a position to whether we can even afford to give law enforcement that inch anymore. Law enforcement has many tools in their toolbox. Kentucky versus King in 2011 in the Supreme Court affirmed that there's no need for a warrant in situations to protect individuals from imminent injury, to get to pursue a suspect in hot pursuit, or to prevent the imminent destruction of evidence. So although we're not taking away the use of a dynamic entry for law enforcement, this bill simply just addresses the use of no-knock warrants in entering somebody's home. So in balancing the interests of public safety with the rights of Minnesota's law-abiding gun owners to defend themselves against intrusion into their home, as well as officer safety, I think it's really past time that we evaluate the efficacy of no-knock warrants here in Minnesota. Thank you.
Great. Thank you for your testimony. Last on the list, I have Spring Sendell. I apologize if I'm pronouncing your name incorrectly. Please go ahead and introduce yourself and go ahead with your testimony.
Thank you. Good evening, Madam Chair and members of the committee. For the record, my name is Spring Sendelli. I'm a law student at Mitchell-Hamlin School of Law, and I've also been involved in the research on no-knock warrant reform through Mitchell-Hamlin's Police Reform Turning Point Project. However, I speak to you today, or this evening now, not as an academic, but as a former law enforcement officer. My law enforcement career spanned over 20 years. I was a police detective, supervisor, use of force instructor, and training officer. I've served many knock and announce warrants and some no-knock warrants. The no-knock warrant reform bill should not be looked at as endangering the safety of law enforcement, but rather as protecting both officers and the public. Because the Second Amendment allows the public to keep and bear arms in their homes, and the Castle Doctrine allows people to protect their homes, the use of no-knock warrants places well-meaning officers in a vulnerable position with regard to constitutional rights. The recent trend of holding officers accountable in a court of law when situations do not go as planned should be enough to give officers pause about serving no-knock warrants. We need to ask, is the juice really worth the squeeze? In other words, is the danger of serving a no-knock warrant really worth the potential risk? This bill does not hamper officers' ability to obtain a no-knock warrant when they likely have no other alternative, when the circumstances are sufficiently grave for everybody involved. For the other times, officers have an incredible amount of discretion how to do their jobs, how to investigate a crime, and when to seek and execute a search warrant. If serving a knock and announce warrant is viewed as just too dangerous, then perhaps officers and supervisors should put their heads together and do some good detective work to figure out a safer way or safer time to serve the warrant. Taking that time will certainly be less costly in all respects than if an innocent person is harmed. What we need to remember is that it is just as important to protect innocent people, including law enforcement, as it is to arrest a guilty person. For that, there will always be another day. Thank you for allowing me to testify today. I'd be happy to stand for any questions.
Yeah, thank you very much for your testimony. With that, members, that wraps up our testifiers. I believe there is some things submitted in writing as well. Before we move on to member discussion, just want to remind members that we did have I want to acknowledge the very good presentation from Ben Johnson in House Research. That was exactly a month ago today on February 22nd regarding Fourth Amendment and search law. And so with that, we'll move on to member discussion. Representative Johnson.
Chair Becker Finn, Representative Representative, remember correctly, Hollins. I have a lot going on today, trying to keep everything in perspective. There's a couple of issues I have with the DE amendment. One is subdivision 3A, which permanently bans no-knock warrants. As somebody who has actually executed multiple search warrants, the vast majority have been knock and announce, but I have done a few no-knock warrants. Brings to mind one search warrant. It was a no-knock warrant. Instead of kicking the door, we actually checked it. It was unlocked. We went in, and when we saw the individuals, we announced ourselves, telling them to hands up, police, search warrant. When we did that, all three suspects were armed with handguns in their belts, shotguns and ARs at their side, right by them. If we had kicked the door in, or even did a knock and announce, they had the barricades in place to put down if we would have knocked and announced. And they had the firearms on them to use. The Breonna Taylor case was cited, and the investigation showed that even though it was a no-knock warrant, the officers did knock and announce, and the gunfire came through the door at the officers. And now it comes back to another issue I have. I'm going to ask a question if Representative Hollins can answer. In subdivision 2, it changes how a search warrant is done. Is it the intent that every search warrant, the way this is written, is every time a search warrant is done, the officer has to knock loudly, announce his present loudly, and wait at the door 30 seconds before they can do anything else?
Representative Hollins.
Thank you, Madam Chair. Thank you, Representative Johnson. Yes, that is the intention at this point. We have talked to law enforcement about potentially changing the time limit on there to 15 seconds or some other amount, but we do think it's important to designate a length of time, specifically because when we spoke to law enforcement, they said the difference between a knock and announce and a no knock is literally could be 2 seconds. And it's our strongly held belief that that's not acceptable, and it puts officers and citizens in the exact same amount of danger if they knock and yell police and then kick in the door, especially when we're talking about the middle of the night when people are asleep or, not fully conscious.
Representative Johnson.
Representative Hollins, I have a lot of concerns with that. That's an officer safety issue. A lot of times when they do these search warrants, they use flashbangs. It's giving an opportunity, and it also waiting 30 seconds gives an opportunity for evidence to be destroyed. Gives an opportunity. Sorry about that. That was 30 seconds from the time Representative Hollins stopped talking until the time the alarm went off. It's a lot of time. We have individuals inside the home injured or killed. We can have doors barricaded, making it much harder and making a much different situation. We can go to a hostage situation. The search warrants are set up and they're done strategically to try to make it with the key word of safety to the officers and the individuals that are inside the home, that are known to be inside the home, to the best of the officers' knowledge to be safe. Officers want nobody hurt. They don't want the victim. They don't want anybody hurt. They don't want the perpetrators hurt. They don't want the subjects of the search warrant hurt. They don't want themselves hurt. I don't believe you've ever been involved in a search warrant or understand them. I know Representative Grasso, Representative Novotny has. They've been through it. We actually generally, in my area, when we're doing a tactical search warrant, where we know it could be a serious issue, we have EMS on site with us. They train with us doing these search warrants and how to do them because we know they're dangerous. We have a protocol of how to get them. In fact, one of the testifiers wrote it off or read it off. It's unfortunate that some investigators doing these are not doing their due diligence and doing their work. But you shouldn't blame every officer. Let's look at where they went wrong, find out why they went wrong, and correct the problem. Not make everybody less safe. Doing and waiting 30 seconds is making things a lot less safe and a lot more dangerous to the people inside and for the officers themselves. Right now, the way this is, there's no way I could ever support anything like this. And the last testifier we had didn't know that it was a DE amendment banning the search warrants at all by her testimony. So I think we need to take a step back, look. We had this unfortunate situation in that with the Lockheed issue. It's been a while. They've looked at it. We're still waiting to hear if anything's going to happen, but we need to let the investigation continue and look at all the circumstances, look at everything, and make a rational, intelligent, informed decision. Thank you.
Thank you. And I will note just to kind of level set here, we all bring important, diverse backgrounds and experience to this committee, and everybody's experience is valuable. So I want to level set and state that it's important that we hear from folks who have worked in law enforcement, who have worked in prosecution, who have not worked in either of those places, and we all have rights. And so I think it's important that we value everybody's point of view on this. I will also say I thought the last testifier was excellent and really appreciated her perspective as both a law student and her time in law enforcement as well. With that, we'll move to Vice Chair Moeller.
Madam Chair, I'm sorry, can I respond really quickly?
Yeah, go ahead. Sorry, Representative Hollins, go ahead.
Thank you so much, Madam Chair. There was just a lot there, and I just wanted to touch on a couple of those things. So the first one is the 30 seconds is a best practice that is laid out by the National Tactical Officers Association. It's not something that we just brought out of thin air. So we understand that 30 seconds is a long amount of time, but it's really what we're looking for to make sure that people have the time to comply when officers are there seeking to go into someone's home. And second of all, there was a mention of if this turned into a hostage situation, if somebody was at risk of being harmed, in that situation, exigent circumstances would apply and you wouldn't need to apply for a warrant. And I believe, my understanding is, if you are sitting there and you believe that somebody is actively being harmed in that home, even if you previously went and got a warrant, you would be able to just simply enter that home without any sort of no-knock or regular warrant. And then the third thing I want to say is, Representatives was talking about correcting a problem. It's really hard to correct a problem after somebody's killed. That's a permanent situation. We can't go back and correct officers when that other person's dead. There's no way to make that come back. So that was all I had to say about that. Thank you.
I see Vice Chair Moeller took her hand down, so I'm guessing you hit the exigent circumstances nail on the head, and she's nodding. So moving along, Representative Novotny.
Thank you, Chair. For Representative Hollins, would this apply to Minnesota peace officers assigned to federal task forces?
Representative Hollins.
Thank you, Madam Chair, and thank you, Representative Novotny. That's an interesting question. My understanding is it would, but I would have to double check.
Representative Novotny.
Thank you, Chair.
Representative Scott.
Thank you, Madam Chair. And just a question for Representative Hollins. You gave some statistics at the very opening comments of your presentation today about, I think, injuries from no-knock warrants and injuries or deaths. Were those national stats?
Representative Hollins.
Yes, they were national stats.
Okay, thank you, Madam
Representative
Chair.
Scott.
Thank you, Madam Chair, and Representative Hollins. You didn't say if they were national or Minnesota, and so I didn't know. I didn't figure it was Minnesota because that would have been a lot for one state. Do you have Minnesota stats that are the same as those that you named with national?
Representative Hollins.
Thank you, Madam Chair, and thank you, Representative Scott. I don't currently have statistics on all of that information. As you might recall, last year was the first year that we passed any legislation on no-knock warrants collecting that data. And so the information that we have is only started from, I believe, September of 2021. So it really isn't very much, but from that information, we were able to glean where they are most often used. And also who they are, I don't want to say used against because that sounds forceful, but who they are sought for in particular. So men, women, race, etc. And I'm happy to share that information if you want.
Follow up, Representative Scott.
No, that's it, Madam Chair. I just was curious. Thank you.
Yep. Representative Long.
Thank you, Madam Chair. I wanted to thank Representative Hollins for all of her very hard work on this bill, pulling it together, and all of the stakeholder conversations that she's been engaged in. And I just wanted to note some of the data that Representative Hollins was referring to for the which jurisdictions are using no-knock warrants across the state. A lot of the conversations I've had with individuals across the state is that these are not widely used in all parts of the state. Many jurisdictions might use them once a year, once every few years. It seems like in greater Minnesota, they're used a lot less often than they are in particular metro areas. And InPost did an analysis of where no-knock warrants are used, and it turns out that there are 3 jurisdictions that use well over half of the no-knock warrants, at least from recent data. Those are my city, Minneapolis, Hennepin County Sheriff, and St. Cloud. And we heard from the St. Cloud Police Chief in our last committee stop. But in Minneapolis, they're ending this practice. The mayor has declared that they will no longer use no-knock warrants and is using a similar timeline approach to the one in Representative Hollins' bill and the best practices that are outlined. So one of the 3 jurisdictions that are over half of no-knock warrants currently in Minnesota is ending this practice. And so I think that's a step in the right direction. I think we're seeing that these are not widespread right now. We've obviously seen the harm that they can do, and that's been provided movingly by this testimony. So I just want to thank you, Representative Hollins, for bringing this bill forward, and you have my full support.
Thank you. Representative Grossell.
Thank you, Madam Chair. And if I turn the camera on, it'll start blurbing out. So I'm just going to leave it dark if that's okay. So, and listening to the testimony and the explanation for the bill and such, Representative Hollins, have you looked around to see the massive increases in violent crimes in Minnesota?
Representative Grossell, I don't think that's too. Can you, Representative Grossell, you gotta let me finish my sentences.
That's why I apologize.
Yep, we're going to stick to the bill, and I can tell by, maybe you can't see her, but I can tell from Representative Hollins' expression that she and I are both not seeing how that's related to the bill. But if you want to restate your question in relation to the bill before us, that would be great.
I will do that. With the massive increases in violent crime in the state and predominantly in the metro area, You stated that, and other representatives and such have talked about how little these no-knock warrants have been used and where they're primarily getting used. Isn't it a bit of an overshot to want to eliminate no-knock warrants completely, or make it, because it takes a lot to get a no-knock warrant. There's usually very good reason, and you have to articulate that, and the judge has to sign off on that. So if I guess why do we want to remove a tool that is not used real often, but when you need it, it's vitally important. So I go ahead.
Representative Hollins.
Thank you, Madam Chair, and thank you, Representative Grossell. I think I understand the question that you're asking, and I guess my response would be, first of all, it is a tool, but we know that it's a tool that is not needed all the time. There are many, as I said, there are many jurisdictions that don't utilize it. There are states that have banned it. The state of Florida, where you probably would most likely think of drugs being flushed down the toilet, has not used no-knock warrants since 1994. Nothing against Florida. And so I see what you're saying about removing a tool, but I will counter with, this tool is too risky to use. If there was a medical procedure that, occasionally helped but often killed people, we would not be so inclined to use that tool, even though it might occasionally help. And the other thing I wanted to address in what you were asking is the reality that I don't think no-knock warrants are going to prevent violent crime. That is something, when we do a no-knock warrant, it's a search warrant after the fact. If we think that somebody is in harm's way and is at risk of being harmed, then you wouldn't need a no-knock warrant. You wouldn't need any sort of warrant. You would simply enter, because that's an exigent circumstance. And so I don't really view no-knock warrants being connected to violent crime. And I think with good reason. I mean, no-knock warrants have been used to prevent the destruction of evidence for the most part. And the final thing I'll say is I understand and respect when law enforcement has told me there is a long process to get a no-knock warrant, but I'll also cite numerous cases that we have seen where the application did not warrant a no-knock warrant, and yet it was granted. The one that comes top of mind is the puppy napping case that was just brought to light in Minneapolis. There was no risk of flushing a dog down a toilet or throwing it out the window. There was no reason to invade someone's home at 6 o'clock in the morning while they were naked and sleeping to retrieve a stolen puppy. And yet that no-knock warrant application was signed off on by a judge. And so for that reason alone, I think that we absolutely need to dial back how we use this tool, and in my mind, get rid of it altogether. Thank you.
Quick follow-up, Representative Grossell.
Thank you, Madam Chair. And you're exactly right. When something is used like that, then and a judge signs off on it, I can understand that. But two recent cases, one use of a no-knock warrant helped to apprehend suspects that murdered a young man, and without that no-knock warrant, it would have been a lot more unsafe for officers to be able to go and apprehend these individuals. Another one was used. Another shooting occurred, and circumstances being that the young man that died during that search warrant, that is a tragedy all the way around. Nobody disputes that, but they were also searching for a murder suspect. So it is something that should not be taken lightly, and it never is taken lightly as far as applying for and securing an unannounced warrant. And I've written many of myself and had to been on the front of a stack going in to execute unannounced warrants. It's not taken lightly, and it's not done frivolously. And so to take away a tool that can save lives, that can prevent harm to both the officers executing it and the individuals who are the subjects of the search warrant, of the no-knock warrant. You know, I wish you would take a step back and just really look hard at it, because there are other, you know, the destruction of evidence, that's the last of my worries. The only time that no-knock warrants were really pushed for, in my case, was for dangers that were there, threats of violence, et cetera, that came through investigation, that these people are known for violent crimes and so on and so forth. So there are many pieces that need to come together as far as the historical evidence that you need to put together to have probable cause to apply for a no-knock warrants to begin with. So, you know, I won't support a bill that takes a tool away from our law enforcement personnel, especially now when things are, violent crime is skyrocketing and officers are having to do these things, not because they want to, but because some of these crimes call for it and there's a need for it. And until, you know, back to the violent crime, Madam Chair, is that until we get that under control, we should not be taking tools away from our officers. Thank you, Madam Chair.
All right, thank you. A couple of things I want to make sure that we're clear about is that there is a difference between a search warrant and an arrest warrant. And so just to make sure that folks understand that we're talking about a search warrant and not an arrest warrant. That's what is before us in this bill. I also, you know, in listening carefully to the discussion, I think it's important to point out, you know, if your concern is with the crime in Minneapolis and Hennepin County, and Minneapolis and Hennepin County is where most of the no-knock warrants are currently occurring, logically, I'm not sure that it's a tool that's getting the result that you want. You know, it's just that it's a coincidence. Obviously, we don't know exactly why that is, but I think to point that out, that if they were incredibly successful at stopping crime, perhaps that maybe isn't the point that you were trying to make. Representative Novotny, we usually don't go to second bites at the apple, but and we've got two other bills in the agenda. So real quick, Representative Novotny.
Everything is almost have been said. So I'll be very brief.
I was going to say, why'd you raise your hand then, Representative Novotny, if it's all been said? Representative Robbins wants her bill heard. Go ahead, Representative Novotny.
By the time I got there, everybody else had said it. But I'll just respond quickly to you, or your statement there. No one says that a no-knock warrant prevents crime. The goal of the no-knock warrant, at least in everyone that I know's mission, was to prevent further injuries or death. Thank you.
All right. With that, I think Representative Scott, I think your hand's up from before. So Representative Hollins, we'll go to you for closing comments.
Okay, I am unmuted, sorry. Thank you so much, Madam Chair. And I want to thank all of you for your time today and this discussion and your consideration of this incredibly important piece of legislation. We need to make sure that we don't lose any more lives to no-knock warrants. We have grieving families today and every day that want to see that we as a legislature can move swiftly to make change in the wake of tragedy. Please do this for them. Thank you.
Thank you, Representative Hollins. With that, Representative Hollins renews her motion that House File 3398 as amended be referred to the General Register. The clerk will take the roll.
Becker Finn?
Aye.
Mueller,
Aye.
Scott,
No.
Feist,
Aye.
Frazier,
Aye.
Grossel,
No.
Her,
Aye.
Hollins,
Aye.
Johnson,
No.
Liebling,
Aye.
Long,
Aye.
Mortensen,
Aye.
Novotny,
Rodney, no.
Farr,
Or no.
Robbins,
No.
Vang,
Aye.
Zhang.
Aye.
That is 11 ayes and 6 nays.
All right, the motion prevails and the bill is on its way to the general register. Thank you, members, for the discussion, and thank you to our testifiers for sharing their perspectives tonight. 2 more bills on the agenda tonight. Next up, we have House File 3724. Representative Robbins, would you like to move your bill be referred to the general register?
I would so move, Madam Chair. Thank you.
All right. And Representative Robbins, I also understand you have an A2 amendment. Can you tell us quickly what it does? And then would you like to move your amendment?
Thank you, Madam Chair. I would like to move the A2. Very briefly, it has some technical changes where we changed the words user created to user generated throughout the bill. That's a term of art that, we changed it to. Secondly, we have a very brief amendment in section 1, line 17, to say that just tighten the definition we had when it was heard in commerce on what user created content means. And I did that based on input from different communities I had spoken with. And secondly, finally, we also in page 2, line 11, make sure that we exempt filters and algorithms used for parent controls, so that those are exempted under the bill. That was the intent, and we just wanted to make sure that was clear. So, and page 1, line 16, we also specified that it does not include internet search providers or electronic mail. So again, just clarifying language from different stakeholders, Madam Chair.
All right, the A2 amendment is before us. Members, any questions to the A2? It was a very thorough description of the A2. Thank you, Representative Robbins. Seeing no hands, all those in favor, please say aye.
Aye.
Opposed? All right, the amendment is adopted. Representative Robbins, please tell us about your bill as amended. Oh, you're muted.
Thank you, Madam Chair. I'm going to keep my intro remarks very brief because I have a testifier who is currently in practice and has a client meeting she needs to take. So if you wouldn't mind, Madam Chair, I'd like to turn it over to Katie Bell, and then I can just address the bill later.
Got it. Katie Bell, if you want to introduce yourself for the record and go ahead with your testimony, and then we'll go back to you, Representative Robbins. So Ms. Bell, please go ahead.
Yes, hi, my name is Katie Bell. I'm a nurse practitioner, both trained in medicine and psychiatry, and I've been in practice since 2003. I live in the Bay Area and have been practicing in the Bay Area, graduated from UCSF, University of California, San Francisco, and I've been working both in medicine and psychiatry, working with teens and adults, and more specifically in the recent last 8 years, have worked with somewhere between 750 to 1,000 teens at our partial hospital, which we co-founded for severe eating disorders. And Kristen Robbins approached me asking me if I would be open to talking a little bit about what my experience has been working with the teens and social media, and more specifically about TikTok and how this has impacted the teens that I'm working with and been a risk factor as part of the development of a severe eating disorder. So I was just going to share some of the testimonials that I've received from teens. I was interviewed for the Wall Street Journal article that came out December 18th that highlighted the algorithms of TikTok and how predatory those have been. And I'm just going to share some of the testimonial that the teens shared with me. Is that going to be helpful for you? Okay.
Yeah, please go ahead.
Yeah. So what the teens, when I asked them about this in preparation for the December 18th article, and I've gotten some, additional information from the teens since then is basically TikTok has served for them to be a really great distraction, but it's basically become the new eating disorder on from Tumblr. So people have transitioned over from Tumblr to TikTok. And the main thing is that there are a lot of weight loss trends that are trending on TikTok. One of the teens shared that they'll show healthy images on TikTok, but then those healthy images become unhealthy. For example, a teen would be showing about the recovery, but then as part of the recovery, they're showing them on a feeding tube and in a hospital, and really, actually quite unhealthy. And the teens that had viewed this said it actually is ultimately very triggering for them. Another teen described that it's presented as though the weight loss is healthy, but then the weight loss, in fact, is not healthy. And an example of this is like, here's what I'm doing for myself to be healthy, but then they'll actually provide, I'm having an apple a day, or I'm having a packet of oatmeal and a single piece of cheese. And so it becomes really crystal clear to the team that it's not healthy, but somehow they get pulled into, like, it's posted as though it's healthy ways to be with. Explain that TikTok has become the skinny girl. She said that on Pinterest, there's an ideal Pinterest girl group, which is very supportive of health at every size for individuals. But she said when you go to TikTok, they present it like it's the Pinterest girl, but it actually ultimately ends up being the skinny girl. Another teen said what would happen is you would get pulled into this body positivity on TikTok. But then when you went there, there was a ton of fat phobic comments in the thread that would follow. And it would make it very triggering for them. Another teen said it's very hard not to use TikTok. The new TikTok trends are what's currently trending and what's really popular. So there was this FOMO sort of thing happening, fear of missing out. And it would pull people in because you wanted to be sure you were on top of everything that was trending on TikTok. Another teen explained that you could present yourself as anybody on TikTok. You could be a medical doctor, you could be a registered dietitian, you could these were influencers that could misrepresent themselves, and how they would pull you in with photos first. They would pull you in with photos first, and then it would end up ultimately being unhealthy. And then ultimately, this was the one thing that sort of, for me, became the most interesting comments, and I heard it from everyone, is when you would try to turn away from TikTok and say, I'm not interested, this was sort of what felt predatorial, is they would still get tons and tons. They would still get an inordinate amount of messages. So this reminds me of the journalists at the Wall Street Journal that pretended that they were 13-year-olds, and they ended up having close to 20,000 suggestions that were coming at them when they put in specific words. And so, that the teens are like, you can't un-TikTok. Once you've entered certain words, then they just continue to come at you. So then I asked the teens, okay, what have you done to not be on TikTok? And ultimately it was to go off of TikTok. I even had one teen say, to sort of avoid the fear of missing out, my sister vets everything, and then she'll show me the funny things, and then she'll make sure I don't see the things that would be triggering for me. So it really landed at not using TikTok or many other platforms of social media was ultimately the best for these teens. And that was really unanimous for the teens.
Ms. Bell, I'll have to ask you to wrap up. We've got a lot of other testifiers yet today.
Yeah, that was it.
Got it. Perfect. Thank you. And thank you for fitting it in. Representative Robbins, we'll go back to you to talk about the bill.
Thank you, Madam Chair. I'll be brief, but this bill, she referenced the Wall Street Journal article. I read 2 different in-depth studies the Wall Street Journal did in the fall. It was just, horrified at the volume and purposely driving harmful content to teens. And, it's something I've heard about. I've listened to the testimony at the federal level. I've been concerned about it as a parent. I have 3 daughters. when they still lived at home, we were very careful with social media and had a lot of rules around what they could do and how much time they could spend on it. But I think things have gotten so out of control that we just cannot wait any longer for the federal government to take action. Everyone says there's nothing the states can do, and I just fundamentally disagree with that. I have looked into the law everyone cites, Section 231 of the federal level, and the immunity provisions are quite limited. And I think there is an exception for states. States still can bring laws, and I think it's incumbent on us as Minnesotans to try and protect our students, our young people. So the bill basically says that any social media platform cannot use algorithms to drive content to kids. The kids can be on the platform. It doesn't say anything about the type of content. It's just that they have to affirmatively like content, and their newsfeed is only populated by things they have chosen. It cannot use the algorithm to drive content to them. And it's kind of a bright line. I recognize that, members, but I'm to the point, and I've got a lot of other articles and testimony and things I could share with you, but I don't know how else we can help get kids to be protected from this just onslaught of really damaging content that they get sucked into. And so that's what the bill does. Thank you.
All right, thank you. And we do have several other testifiers. Next on the list is Stephanie Zerwas. Please introduce yourself for the record and go ahead with your testimony.
Thank you, Chair Becker-Finn and members of the committee. My name is Dr. Stephanie Zerwas. I'm an associate professor at UNC Chapel Hill in the National Center of Excellence for Eating Disorders, where I'm also a clinical psychologist. I'm also the mom of a tween and a teenager. I specialize in the research on the development of eating disorders and treat teens and young adults. And I'm here today with my therapist hat on. I want to share how social media algorithms are contributing to a rapid surge of new eating disorder cases in teenagers in Minnesota and in the country. And it's important to provide some context. Eating disorders like anorexia or bulimia are often dismissed as just a phase or a fad, but these are devastating, expensive, and life-threatening conditions that families face every day. They are among the most deadly mental health conditions, second only to opioid use disorder, and they kill over 10,000 Americans every year, or one person every hour. We also know that eating disorders do not discriminate. They affect people of all races, ethnicities, genders, sexual orientations, and body sizes. And over the past 2 years, we've seen a doubling in the number of kids who have come into treatment and sought treatment for an eating disorder. And every week I received phone calls from parents who are desperate to find a therapist for their child. So why is it happening during the pandemic? The stories I hear from teenagers are eerily similar. They tell me again and again that their eating disorder started when they fell into these dieting, exercise, and eating disorder rabbit holes that were driven by social media algorithms. There's this deja vu that happens when I hear teenagers describe this experience. They don't go looking for eating disorder content. They say that they'll spend an extra second looking for like a spring break bikini. And then the algorithm floods their social media feed with risky dieting tips. And that quickly intensifies to include specific eating disorder content that coaches them on how to lose weight, but also how to hide vomiting from their friends and family, for example. It normalizes their eating disorder behavior. They start to believe that everybody has an eating disorder or is keeping it secret. It's like turning on your TV and every single channel is playing the same thing over and over again. And it changes your perception of reality. These algorithms also reward teens for sharing risky posts themselves with other teenagers by giving them lots of likes and lots of attention and lots of views. And finally, many teenagers report that they end up deleting their social media altogether, but they say that once they've seen all this content, once they've started to have these thoughts, they become indelibly tattooed on their brain. They can't unsee it anymore. It's Not all teens who witness this content on social media will go on to develop eating disorders, of course, but we know that teenagers are at this critical time of identity and habit formation. And once these thoughts and behaviors begin, it can be extremely hard to shift them without expensive treatment. We know that social media algorithms are throwing gasoline on the fire of eating disorders. These existed prior to the advent of social media, but we've never seen anything like what we're seeing in the clinic right now. They present a world where everyone is obsessed with dieting, eating, excessive exercise, and these really toxic body comparisons. We know from testimony—
Dr. Zerwas, I have to ask you to wrap up out of respect to the other testifiers.
Sure. Our children's well-being is just too precious, in short. This is a time where we're facing lots of things that are out of our control, but this is something that's in your control. You can really prevent the damage that technology giants inflict on youth for their own gain.
Thank you for your testimony. I have a couple other testifiers. I have Adam Kovacevic from Chamber of Progress. Please introduce yourself and go ahead with your testimony. Or not. We'll move right along. I've got Jennifer Huddleston. Please introduce yourself and go ahead with your testimony.
Thank you, Chairwoman Becker-Finn. My name is Jennifer Huddleston, and I'm a policy counsel with NetChoice. NetChoice is a trade association dedicated to keeping the internet safe for free expression and free enterprise. I'm also a former educator, and so I understand that many people are concerned about the type of content that teens and young people may be seeing online and offline. However, tonight I ask you to oppose HF 3724. I've submitted a written statement for the record that discusses some of the concerns with regards to the impact this could have on parents' decisions, as well as on positive experiences for teens and young people online. But tonight in my testimony, I'd like to focus on two key points. First, the impact that this bill could have on the collection of information around teens and young people, as well as, with this being the Judiciary Committee, some of the legal concerns contained in this bill. So to start with, I know that data privacy has been a concern for many on this committee. Unfortunately, this bill could actually lead companies to have to gather more information on Minnesota teens and young people. If this bill was to be technologically feasible, companies would have to be able to distinguish what users it applies to. This may mean collecting more information around the age and location of a user that wouldn't otherwise need to be collected. But beyond this concern, I'd like to point out key legal concerns with this bill related to the First Amendment and the Dormant Commerce Clause. When it comes to the First Amendment, there are concerns stemming from Sorrell v. IMS, the Supreme Court decision that ruled that information is speech and that a Vermont law could not prohibit the creation and dissemination of information, including the selling of data to a database. Even more relevant, there are multiple court cases that have held that the distribution of speech, including the use of algorithms, such as those used by search engines, is protected by the First Amendment. While there may be a government interest in protecting minors from harmful content, it may not be done in such a way that would prevent adults from accessing otherwise constitutionally protected speech. And in fact, in Ashcroft v. ACLU, the Supreme Court struck down a federal law that attempted to prevent the posting of content harmful to teenagers on the web due to the impact as well as the harm and chilling effect that the associated fines could have on legally protected speech. Additionally, I would point out that there are key distinctions in a proposal like this and the type of proposals around things like filters on library and school computers that we've seen come up in other scenarios. Additionally, I would like to raise—
Ms. Huddleston, you'll have to wrap up.
Yes, ma'am. My final concern would be to point out some uncertainty around the Dormant Commerce Clause. It's very unclear when this bill would apply, and I would just like to raise two such situations. So, for example, if a Minnesota teenager is on a class field trip to Washington, D.C., does the law still apply to their content then? What about an Arizona teenager who may be visiting their grandparents in Minnesota? These are the types of problems that the courts and companies will have to encounter if they were to have to determine compliance, as well as the technological feasibility. I thank you for your time, and I welcome any questions.
Thank you. And just for the record, when I tell you to wrap up, it doesn't mean that you should just talk really fast. It means you have to wrap up. And that's why we communicate with everybody ahead of time that you need to keep your testimony to 2 minutes. We are timing you, and it's out of respect for everybody else. Moving right along, Mr. Deers, please introduce yourself and go ahead with your 2 minutes of testimony, please.
Yes, thank you. Good evening, Madam Chair, members of the committee. Tyler Deers with TechNet. We are opposed to this legislation. I know I've had conversations with the sponsor. I think it's just a philosophical opposition on how best to approach this bill with any kind of legislative solutions. The internet runs on algorithms, and this bill, as mentioned, would seek to ban algorithms on social media for Minnesotans who are under the age of 18. They are used. Algorithms are used every day in our life. Every one of us today have encountered an algorithm, and it likely made our lives easier. When we appreciate the conveniences they provide. However, when it's used in the context of social media and teenage use, we automatically associate algorithms with being bad, but only if they are being used by the private sector. I noticed in the bill that the government has a special carve out. Government algorithms are okay under the bill. When anyone else uses them, they are considered nefarious. There are many beneficial uses of algorithms in social media that would be impacted should this bill become law. Social media algorithms are a way of sorting posts in a user's feed based on relevancy instead of published time. If a platform doesn't show users things they're interested, there's really nothing there on the platform. So algorithms are built to learn what our preferences are, and as opposed to when they were posted. I did get to see the chance the proposed amendment prior. We're glad to see that there is acknowledgement that there are beneficial uses of algorithms, such as blocking harmful content, such as pornography and gore. But what about other items, such as spam or misinformation about vaccines? Not to mention, as was mentioned by Jennifer, this bill will bifurcate social media platforms, one for those over the age of 18 and one for those under the age of 18. But in order to comply with those requirements, my members will have to collect more personal information on its users and track and make sure that they are under the age of 18 and that they are indeed from Minnesota. So at a time when there's ongoing privacy discussions, this seems to go in the wrong direction. This body just passed a $1 million grant last year to promote a balanced and intentional use of technology on youth in the state. The goal of the grant was to discuss a lot of these issues. The grant's not even haven't even been in effect for 1 year. So perhaps, we should examine the success or lack thereof of the Live More Screen Less grant. Does it need more money? Does it need more studying? I think, that's an appropriate conversation to have, I believe, in this context. Again, thank you for the time, for allowing me to be here, and I'd be happy to answer any questions that you may have.
All right. Thank you for your testimony. I will note for the record that this bill only applies to social media platforms with more than 1 million account holders. And to my knowledge, I don't think our government operates any social media platforms with 1 million or more users. That was the end of our testifier list. We'll move on to discussion. Vice Chair Moeller.
Thank you, Madam Chair. Thank you, Representative Robbins, for bringing this bill. I'm a little troubled by some of the opposition testimony here. Frankly, more than a little troubled by it. With respect to the testimony that this is, collecting more data and this committee cares about data practices, when we're dealing with data practices in Chapter 13, that's government data collected by the government. That's not private data that we're talking about. So just want to make that point clear. I also don't read this bill as eliminating or violating free speech. From my understanding of it, it's a matter of preferences and how things are posted to somebody, but it's not taking down any particular post. And I guess my question for Representative Robbins has to do with that. Am I reading that correctly? You're not prohibiting any speech. It's just a matter of what's shown in a particular order.
Representative Robbins.
Thank you, Madam Chair. Thank you, Representative Mueller. Yes, that is correct. The bill is completely neutral with regard to content. We're not saying anything about what can be posted. We're saying that for users under 18, they can only see things that they have sought out. It cannot be sent to them, directed to them.
All right, thank you. Any follow-up, Vice Chair Moeller?
That's all. Thank you, Madam Chair.
All right, Representative Liebling.
Yeah, thank you, Madam Chair. I just wanted to add one really small comment to Representative Mueller's very good points. And that is, I find it pretty laughable that the companies are telling us that it would violate everyone's privacy if they gathered data on people's age and where they are. My goodness, I think they do that all the time. I just can't believe that that is, the big boogeyman that they're presenting it to be here. I don't think any one of us would possibly believe that they don't already collect that data. So just wanted to make that point. I think it's a very interesting bill, and I don't know if it's completely ready to move forward here, but I appreciate that it's being brought. Thank you, Representative Robbins.
All right, thank you. Representative Johnson, and then we'll go to closing comments. Representative Johnson.
Chair Becker-Finn, Representative Robbins, thanks for bringing this forward. I do find it strange that these companies are opposed to it. And since I already know they're gathering information of where we are, I was recently on a trip to Las Vegas, and my Facebook feed kept showing everything and different things that are happening in Las Vegas. And I didn't even tell anybody I was going, let alone on social media.
Well, now we all know, Representative Johnson. Go ahead.
Yes, I went on a trip with my son to bowl in the National Bowling Tournament, which was a good time. But I just wanted to thank Representative Robbins for bringing this forward. I'm hoping some people at the congressional level, not only in Minnesota, but around the country are watching this. And maybe at the federal level, they'll take this issue up and deal with it to protect our kids. Thank you.
All right. Closing comments, Representative Robbins.
Thank you, Madam Chair, and thank you to all the testifiers. And I do continue to meet with the opponents to work on it. I do think there is some clarifying language that we can provide about whether someone is in the state or out of the state, and I'll be working on that down the road. But I have to say, members, that the First Amendment issues just are not there because I'm not dealing with content. And secondly, the other issue that they brought up about the Commerce Clause and some of the cases they cited, there is wiggle room in this, members. There is I have so many papers here, but if I can find it, the Section 230 clearly states that states can have other laws and there can be an exemption. And so I think we have the space as a state to try and address this. And I appreciate everyone's support in trying to move this forward. And I just also want to clarify that Commerce Chair Stevenson, I did share the amendment with him and he's on board with that as well. So I just want you to know I'm working as much as I can with all of the stakeholders, and I appreciate the opportunity to present this, but don't take the bait, members. This is really important, and we are not harming the private sector. Just a little history. This Section 230 was originally enacted in 1996 as part of the Communications Decency Act to protect kids from online harm as the internet was evolving. That was 26 years ago, members. It has not been updated since, and the federal government, with a lot of effort, has not been able to move the ball on this. And what they were trying to address then algorithms have moved so far beyond that. And this is incumbent on us to try and do something to help kids. So thank you, members.
Thank you. Thank you for your diligence, Representative Robbins. With that, Representative Robbins renews her motion that House File 3724 as amended be referred to the General Register. The clerk will take the roll.
Becker-Finn?
Aye.
Mueller?
Aye.
Scott?
Aye.
Feist? Representative Feist? Frazier? Representative Frazier? Grossel?
Aye.
Herr?
Aye.
Hollins?
Aye.
Johnson?
Aye.
Liebling?
Aye.
Long?
Aye.
Mortensen?
Aye.
Novotny?
Aye.
Barr?
Aye.
Robbins?
Aye.
Bang?
Aye.
Zhang?
Aye.
That is 15 ayes and 0 nays.
All right, the motion prevails and the bill is on its way to the general register. Members, this is our last bill of the evening. I will just say, Representative Wolgamott, you and your testifiers stand between our members and their dinner. So the more we can keep to the point and get going, the better off we are. So I will move House File 3529 be referred to the Human Services, Finance, and Policy Committee. I also see you have a DE1, so I will move the DE1 to get the bill in the shape the author would like. Any discussion to the DE1? All those in favor, please say aye.
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 Aye. Opposed? All right, the motion prevails and the DE1 is adopted. Representative Wolgamott, please tell us about your bill.
Well, thank you, Madam Chair, and don't worry, us Central Minnesotans know how to get right to the point. So really appreciate the time tonight. I'm here to present House File 3529 because law enforcement agencies in my community of St. Cloud and in communities all throughout our state are being challenged by a growing number of calls for service involving people with mental health needs. But unfortunately, Madam Chair and committee members, current law limits law enforcement agencies from sharing data and receiving data that would be helpful for their efforts to respond to calls involving people experiencing a mental health crisis. And current law is an obstacle to how law enforcement agencies can work best with other entities who are providing care for people with mental health needs. I know that this committee has heard legislation about these issues before. I know Representative Hollins had a bill up, House File 864, that addressed a lot of these same issues. And since that time, I've been working with my folks in Central Minnesota, as well as the League of Minnesota Cities, gathering stakeholders. We've got input from law enforcement, county human services, county community corrections, county attorneys, private healthcare providers, and NAMI. And Madam Chair, this bill reflects the work and collaboration of all those entities. So to the bill itself, the problem that we're trying to address is that the threshold for emergency interaction has been interpreted as very high, and there hasn't been the ability to share as much data as could be helpful in responding to these mental health calls. So instead of using the emergency interaction as the threshold for being able to share data, the sections 1 and 2 of this bill, Madam Chair, changes to the threshold to mental health crisis. The two sections also make clear that strategies to address the mental health crisis may be shared with law enforcement. We delete in section 1, we delete the term responsible authority because it's unlikely that the responsible authority in a public entity is going to be the person with the necessary information to help law enforcement with the mental health calls. And then section 3, the final part of the bill, Madam Chair, pertains to the adult protection team statute. So current law allows multidisciplinary teams to meet for case management purposes. These teams generally include county representatives and mental health providers, but we're missing something here. We need to have folks who can provide additional insights. So that's why I'm adding to these adult protection teams, community corrections and local law enforcement, which will mean our city police departments. These are the folks who are now, again, we're seeing an increase in having mental health calls for that. And I'm really proud, and you'll hear more about this in my district in St. Cloud. We have what we call CAT teams, community action teams, that are doing great work to make sure that we resolve these mental health crises in a safe manner. But unfortunately, they're facing these obstacles from current laws. So that's who I've been working with on this bill, Madam Chair. That's why we're bringing the bill forward. That's what we're hoping to address with this bill. And with your permission, Madam Chair, I've got some testifiers from my community who know to keep it to 2 minutes, but have a lot of good insights on why our current law is having obstacles to respond to these mental health crises in a safe manner. So thank you, Madam Chair. And with your permission, we'll turn it over to my testifiers.
All right, the first person I have on the list is Jody Gertkin. Please introduce yourself and go ahead with your testimony.
Yes, thank you. Hello, Madam Chair and committee members. My name is Jody Gertkin, and I am the Director of State Government and Community Relations for Centricare. I'm here this evening in support of House File 3529 and the DE amendment. which would enhance the ability of local jurisdictions to exchange critically important mental health information to coordinate services during a mental health crisis. CentraCare has a long, successful relationship with our local public safety agencies, and we continuously look for new and innovative ways that we can serve the greater St. Cloud area. We are constantly evaluating opportunities to meet the needs of our patients and communities. At CentraCare, it is our goal to provide the right care at the right time and the right location, because we know there's nothing more important than your health and the health and safety of your families. Therefore, we need to ensure we continue to work with essential community partners in endeavors such as these to extend that continuum of care outside of our hospital and clinical settings. The intent of this bill would allow organizations to share important, possibly life-saving information during a mental health crisis. This will help local jurisdictions better respond and support community members in a volatile situation. We take the confidentiality and privacy of our clients very seriously, but we also are acutely aware that mental health issues have escalated exponentially. This bill has been well thought out to ensure that only the minimal amount of information will be shared, and in doing so will help assure the best possible outcomes. Sadly, there are many incidences where outcomes were grave and could have been different if this opportunity to share critical information was available. So it's important to also note that the stakeholders who have put in input to this bill represent numerous disciplines. They've all come together to provide input into the language. So we appreciate Representative Wolgamott for listening to the needs of his community and in authoring this important legislation. I thank you for the opportunity to testify this evening and ask for your support for House File 3529.
All right, thank you for your testimony. Next on the list, I have Blair Anderson from St. Cloud Chief of Police. Please introduce yourself and go ahead with your testimony.
Well, thank you, Madam Chair. My name is Chief William Blair Anderson. I'm the Chief of Police for the City of St. Cloud. And I just want to let the committee know that I am a very strong proponent for this bill. It covers many fronts for us, chief among them being the safety aspect, so that we can mitigate some of the awful outcomes that we have seen nationwide when we are called to respond to folks in a mental health crisis, and we don't know that. The other front that it helps us curtail is the service aspect. And what I mean by that is we are able to get people to the right service providers when we can share information. Oftentimes when we respond to calls, those folks that we are responding to have several different entities that they're involved with, be they Health and Human Services, probation, the Judiciary, police, obviously, and the jail. And as a former jail commander, I can tell you that jails have become a de facto mental health facility, and they are not equipped to handle the problems that they are confronted with on a daily basis. And so let me give you an example here, and so that I stay within my time limits. What we did was we took the 5 people that we have had the most contacts with, where we either put them in jail and detox or on a 72-hour mental health hold. And we used them as our test cases with our community action team, which Representative Wolgamott spoke about earlier. And we had a workaround, which was an MOU and a consent form, so that those entities that those folks are dealing with can all share information. And I can tell you, and I have the proof, I have the statistics, that within 1 year, we had a significantly drastic change in the amount of contacts we had with people than the year before, if that makes any sense to you. Some of those folks we were able to integrate back into our community with permanent jobs, with permanent housing, because we got them to the right service providers. And the largest inhibitor has been the information sharing. And so this bill eliminates that inhibitor for us. And for the folks who are concerned or worried about how that information is going to be used, those things are covered in that bill, right? The information that we gather and that we share cannot be used against those people in criminal proceedings. We only want to use that information to help us better serve them and get them to the proper service provider and to also mitigate some of those horrible outcomes that we have seen across the nation when we are confronted with folks in a mental health crisis, because it's been a huge spike for all of us. And we are not mental health crisis professionals, and I'd be the first one to admit that. So I'm a strong supporter of this bill for those reasons and many others. And thank you for your time. And I'd like to thank the committee, and I'd like to thank Representative Wolgamott and Senator Dietzig. And man, let's get this done. This is something that can work, and it has been proven in our community that it can and will work.
All right, thank you for your testimony. Next, I have Chief Dave Bentrud. Please introduce yourself and go ahead with your testimony.
Madam Chair, members of the committee, thank you very much. My name is Dave Bentrud. I'm a police chief for the city of Oak Park. And I too want to thank Representative Wolgamott for bringing this issue forward. Again, I'm a strong supporter of this bill. And I'm speaking to you from, it's a 30 years of law enforcement professional responding to many calls like this. 20 years as an adjunct instructor in criminal justice at St. Cloud State on crisis intervention. And the last 10 years really is on the board for the Minnesota Chiefs, trying to bring some reforms to our mental health and crisis response. And over the past several months, there have been several meetings involving the league, Minnesota Chiefs, Minnesota Sheriffs, NAMI, and others in developing a mental health responses best practices guide. And it is our hope that this guide will help our police agencies and our communities update or develop even a plan for responding to mental health crisis calls. But this work, and while it's very good work, has also identified some needed changes or reforms, and the previous testifiers have clarified many of those. For years, law enforcement across the state of Minnesota have been responding to situations involving mental health crisis. And while we support the development of alternate responses, realistically, I believe that law enforcement officers will continue to play a significant role in these types of calls for the foreseeable future. And historically, and I would say maybe unfortunately, some of the statutory language that currently exists kind of keeps law enforcement at arm's length, if you will. And it makes it difficult for us to receive the information and go into it as informed as we can be on some of these types of calls. And so, as has been testified to, we're asking the committee to consider some of these recommendations. And I'll just briefly, I don't want to be redundant here, but really what we're asking through this legislation is to allow law enforcement to receive a minimal amount of necessary information to really avoid unnecessarily escalating a situation and to get a safe outcome for all. To be able to make effective referrals, we need to know who to refer to, and that's the other key part of this. And as has been mentioned, to better define emergency situations to include those witnessed escalations in behavior that law enforcement so often sees, and the high utilization of services that Chief Anderson referenced. And really, I think what we're asking is to allow our police officers and our sheriff's deputies to be considered part of the care team, if you will, when it comes to assisting individuals who are struggling with mental health, because we are asked to respond and we are kind of outside the loop in many cases. So in closing, I really encourage you to support this. What we really need to do is to continue to encourage and support the collaboration that is taking place, promote multidisciplinary, multi-jurisdictional teams to address these issues. But for these teams to be effective and successful, they need to be able to effectively communicate, share information to really benefit those that we serve. So thank you for this opportunity to make some comments.
All right, thank you. And I'm trying to be very respectful of everyone, but 2 minutes is 2 minutes. And please remember, our committee has been in committee for 4 hours already today. So if you're going to say something duplicative, you don't need to say it. The next person on the list is Nikki Niles. Please introduce yourself and go ahead with your testimony.
Good evening, Madam Chair. I am Nikki Niles, Director of Dodge, Fillmore, and Olmsted County Community Corrections. Thank you for this opportunity to testify on behalf of AMC and MICA in support of House File 3529. In Olmsted County, we've implemented a multidisciplinary team consisting of social workers within County Corrections Department who work in partnership with the Rochester Police Department and the Olmsted County Sheriff's Office. The team works together to respond to calls for emergency and non-emergency services to address public health concerns, such as mental health, chemical health, substance abuse, and well-being. This program has been working well. It's demonstrated the introduction of not introducing clients into the criminal justice system, as well as getting clients out of the criminal justice system who exclusively have public health concerns. But we are finding that some data sharing laws are too limiting to offer the needed assistance to the people that we serve. Members of this outreach team need the ability to talk with one another and community partners, both internal and external, to the organizations to effectively do the work. Current statutes only allow, in most instances, one-way communication. For example, social workers to law enforcement to medical staff, corrections to social workers. This legislation changes that to allow members of multidisciplinary teams to communicate with each other. Only very specific and necessary mental health data will be shared and will be classified still as private data. Overall, these changes will help emergency responders' ability to help the people more quickly and effectively. Since the implementation of our co-responder team over a year ago, there have been several instances where the social workers have needed to communicate with other partners, such as law enforcement, Mayo ER, Olmsted Medical ER, community mental health partners, and/or social workers within the county. This statute change would allow for minimum necessary communication and/or data sharing between these entities. If I may, in closing, I'd like to note that not all jurisdictions across our state have the resources to have a co-responder model team, as we do here in Olmsted County. In those respective jurisdictions, all these type of calls solely fall mostly on law enforcement. The language of this bill makes situations like these efficient, most times without having the person in crisis then placed into custody to truly receive the services that he or she may need. We thank Representative Wolgamott for authoring this legislation, and thank you, Madam Chair, for the opportunity to testify in support. I'd be happy to answer any questions. Thank you.
All right, thank you for your testimony. Next on the list, I have Terrell Clark. Please introduce yourself and go ahead with your testimony.
Thank you, Madam Chair and members. I'm Terrell Clark, Stearns County Commissioner. I am joining Nikki Niles today. I'm speaking on behalf of AMC, MICA, and Stearns County. And as you've heard, few medical and public safety emergencies are more heartbreaking than when an individual struggling with mental health crisis spirals into a public safety crisis and a potentially dangerous or even deadly outcome. Counties often play a central role in these situations, whether it be through social services, community corrections, or law enforcement. Every day, more and more counties are realizing they need to break down silos of government and work together with our community partners to better serve communities. A big part of working collaboratively across departments is being able to share information necessary to provide clients with the services they need. And in doing so, protection must be given to private data. This bill provides a balance of increased data sharing for intervention during a mental health crisis without sharing more information that's necessary. Personal data privacy is an essential right that our members believe in. Increased sharing of personal data should only be used in exigent circumstances where the exchange of limited information can make a real difference for the person and improve how a situation is handled. This is especially true when someone in crisis interacts with county workers. Two quick examples that probably highlight maybe even more than what we've heard already. One, these are both Stearns County examples. Our partners will hear them being familiar. A client who was placed with Stearns County with a CADI waiver, placed in an REM home from a different county. We were not the county of financial responsibility. She had multiple crisis situations, including several suicide attempts. She interacted frequently with the police department as well as staff in her REM home. She utilized our crisis beds and on occasion detox. There were several problems communicating with her other county workers and previous providers.
the other county couldn't release information pertinent to help her during these calls. Thanks to our community action, team release and releases from the other county to help find a better placement for the client and also a better location. This wouldn't have been the case without our CAT team and release. A very specific one that might help, Madam Chair.
And actually, that's I'm going to have to ask you to wrap up.
That's fine. Could we wanted to give a few very specific examples so your committee would know how narrow this is in terms of what could be released. If you don't think it's necessary,
if members have questions, they're welcome to ask. I mean, this is why we communicate with everyone ahead of time that you've got 2 minutes. So you might have to pick your favorite story in the future. But if members have questions, we can certainly get there. But I want to make sure we do have time for those questions.
Well, thank you. And if there's any questions, and thank you, Representative Wolgamott, who is my representative.
All right, thank you. Last, I have Natasha Chernyavsky. Please introduce yourself and go ahead with your testimony.
Hello, good evening, Madam Chair and members of the committee. My name is Natasha Chernyavsky, and I'm the Legislative and Policy Specialist for Citizens Council for Health Freedom. And I'm here tonight to actually share our concerns with HF 3529. I would like to speak briefly to the statute that this bill is proposing to change. Currently, Minnesota has the strongest medical privacy law in the entire nation. This is the Minnesota Health Records Act, or Minnesota Statute 144.293. The MHRA requires consent before patient data is shared for any reason, except for 3 break the glass exceptions, which are first, in the case of a medical emergency, when the patient is unable to give consent. Second, to other providers within the related healthcare entities when necessary for current treatment of the patient. And third, when a patient is returning to a healthcare facility and is, in that case, unable to give consent. Unlike in the case of the exceptions I just listed, individuals with mental health issues under the proposed legislation would be denied the right to give consent. But I think it should be kept in mind that these individuals can still choose to give or withhold consent for sharing their medical data records. HF 3529 is essentially arguing that a person's struggle with mental health justifies taking their privacy and consent rights away when they encounter a law enforcement or emergency response team. We believe that it's wrong to deprive someone of their consent rights because they have a mental health struggle, nor does having mental health issues take away an individual's constitutional right to privacy. Patients can already choose to voluntarily share their mental health data with many law enforcement departments in Minnesota through the Vitals Aware app. This app allows individuals to share their mental health diagnosis with law enforcement who are within 80 feet of the individual. And this enables law enforcement officers to know a person's diagnosis before they approach. The Minnesota Health Records Act protects the rights and privacy of all Minnesotans. We do not support taking these rights away from citizens who struggle with mental health issues. Therefore, we oppose HF 3529 and urge the committee to maintain our law's strong protection of privacy rights for every Minnesotan. And I'll stop there to keep it short. However, I am available for further comment, and there is a lot more I could say about the importance of protecting an individual's rights, even if they're struggling with mental health.
All right, thank you for your testimony. We'll move on to member discussion. Representative Scott.
Thank you, Madam Chair. This question would be to Representative Wolgamott. Representative Wolgamott, how's this data being protected? I mean, there's a lot of sharing going back and forth here. I mean, all the testifiers were talking about all the places that this data is being shared. Who's protecting it in this bill?
Representative Wolgamott.
Well, thank you for the question. Thank you, Madam Chair, and thank you for the question, Representative Scott. Again, we have put a lot of work into this bill on trying to strike that balance of protecting the privacy of individuals while giving our law enforcement and other social services folks the support that they need to respond to mental health calls in the best way possible. To further shed light into, I guess, from my point of view, it really depends on the situation. It depends on the investigation and the scope and the depth of the investigation that's happening. I know that I have Miss Irene Gao, who's on from the League of Minnesota Cities, who's been working with stakeholders on this bill. So, Madam Chair, I think that Ms. Gao could best answer Representative Scott's question.
All right, Ms. Cow, please introduce yourself for the record and go ahead with your testimony.
Madam Chair, members, my name is Irene Gowen. I'm with the League of Minnesota Cities.
Representative Scott, it is a really important question. As the current law is, and as the bill would provide.
And members, if you're not Irene, can you mute, please? Thank you. Go ahead, Irene.
Thank you, Madam Chair. As the bill would provide and as the current law is, the data would be classified as private and it would have to be maintained accordingly. As you can see, we did try to work within the confines of what already exists in the law related to welfare data, as well as what was mentioned earlier in the Health Records Act. And so it would be the same confines, and as you know, in data practices, there are still responsibilities for government entities to ensure that privacy. The other thing too is that in this area of law, it can only be used for this purpose. And in this case, the bill would identify to safely resolve the mental health crisis. And it could not be used for any other purposes.
All right. Follow-up, Representative Scott.
Thank you, Madam Chair. I'm not sure there was an answer in there about how it's being protected, who's protecting it. I just envision this group of people sitting at a table, especially in the example that the St. Cloud police chief gave of working with these 5 individuals. And I don't deny that law enforcement needs a tool for helping these people when they're in crisis situations. But I just envision these people sitting around a table on a Zoom call, and they've got all this personal data on somebody, and there's no audit trail in this. If word gets out about somebody's mental health situation, how will they ever know where that came from? There's no audit trail. There's no real accountability in this bill, in my opinion. And Madam Chair, I do have a question for the police chief from St. Cloud. I forget his name. I'm sorry.
Chief Anderson.
Yes, if I could ask him a question, please.
Yep, go ahead.
Chief Anderson, you mentioned that with these 5 individuals that you gave the example of, that you got the consent of those people. I'm pretty sure I heard you right on that. Is that correct?
Chief Anderson.
Thank you, Madam Chair. Yes, Representative Scott.
Representative Scott.
Thank you, Madam Chair. So I know that it's not in every situation that you're going to be able to get someone's consent, but Representative Wolgamott, I would be glad to work with you on this to get some language in there that says when it can be obtained to get people's consent. And I think that's one of the first things that we could do towards making this bill a little bit tighter. But again, I understand what's trying to be done here. I think this bill is just too loosey-goosey on who's going to be accountable for all of this shared information, very sensitive data. So I won't be able to support it. Thank you, Madam Chair.
Madam Chair, can I try and answer, please? I don't want to be out of order.
Yep. Hold on. I've got multiple people raising their hands. So let me pick one of you. Chief Anderson.
Representative Scott, and thank you, Madam Chair. Representative Scott, I think the answer to your question is all of us are responsible for protecting that information, because there are provisions in the bill that make sure that we protect that information. And one of the big inhibitors for us getting people to the right service providers is having to try and negotiate that bureaucratic red tape, for lack of a better phrase, that helps us more quickly get people to the places that they need to be. And not all people that we encounter in a mental health crisis have the capacity to necessarily give us consent. And that doesn't mean that we want to violate their rights. We're trying to help them. And so my question then rhetorically would be, what would you have us do? We're trying to help these folks, and we've seen some of the awful outcomes across the nation and in our own state when we don't have the information that could possibly help us mitigate that. Thank you, Madam Chair, for letting me comment.
All right, Representative Wolgamott, was that sufficient for a response?
Yes, Madam Chair, I have something to say to that, but I don't want to be duplicative out of respect for you and your committee's time.
Yep, and you'll certainly get the last word as well, Representative Wolgamott. Representative Johnson.
Chair Becker Finn, Representative Wolgamott. Thank you for bringing this forward. Law enforcement has been dealing with this issue for decades upon decades. We've been asking for help. Back in mid-1980s, early 90s, we're begging for help. It's taken over 30 years to get to this point, which is way too long. As far as the data protection, law enforcement is used to protecting data. We do it every day. In fact, a lot of our data is protected under Chapter 13, just like this bill already reads. All this is doing is adding law enforcement, those who are actually on the front lines dealing with these people, to the team that is going to work with them, with the data being protected the same way it is now with those other professionals. But giving law enforcement the opportunity to know who the case manager is, so when they deal with them, they can give that case manager a call to get that person the help they need instead of bringing them to jail. Because right now, we don't know that information. We have an option. Leave them on the street where they can be danger themselves or others, or bring them to jail. This gives us an option of how to deal with them, how to get them the help they need, which is very important. With that information, we're going to be able to direct them where they need. We already know who they are, especially in our smaller communities. Especially in our smaller communities, as we deal with them on a regular basis, we call it the revolving door. We pick them up, we bring them to jail, they go to a treatment center. Under the Jarvis ruling, they're given their meds, they get out. A month later, they feel great, they quit taking their meds, and at the 4-month mark, we're now dealing with them again, starting the whole process all over again. If we know who their social worker or their caseworker are, when we start seeing those signs, we can actually intervene before we have to start that revolving door, which is what we want. We want to make sure that they're on their medications. We want to make sure they're getting the help they need. And this bill is going to help us do that. So thank you, Representative Wolgamott. And I am going to be supporting this because I believe it's very much needed. Thank you.
All right, Representative Hollins, and then we're going to close and get everybody some food. Representative Hollins.
Thank you so much, Madam Chair, and thank you, Representative Wolgamott, for bringing this bill. I really love this. I think it's a strong bill, and I'm pretty excited about it. And I was wondering if either you or Ms. Cow could tell us more about who all the stakeholders were that were involved in crafting this. Thank you.
Representative Wolgamott.
Thank you, Madam Chair, and thank you, Representative Hollins. I'm excited about it too. The stakeholders that have been working with Ms. Gow and the League of Minnesota Cities include law enforcement agencies, so police chiefs, sheriffs, the Minnesota Peace and Police Officers Association, as well as county human services, county community corrections, county attorneys, private healthcare providers, like Century Care, and I want to thank Jody for being on tonight, as well as NAMI. So it's been just a really rock solid team. And again, we are working so hard to strike that perfect balance of protecting people's privacy, but making sure that all these entities can access the information that they need to be able to respond to these mental health crises in a safe manner. So those are the stakeholders, Madam Chair and Representative Hollins.
All right, and Representative Wolgamott, if you want to go straight into your closing, please go ahead.
Well, sure. Well, I don't want to get between you and your committee members and food, Madam Chair. So I'll just say, once again, thanks for your consideration for this. We as a state want to show commitment to mental health and making sure that we're supporting Minnesotans with mental health issues. So I would urge your support for this. I will ask for your yes vote to send this bill out of this committee and through the process so that we can empower our law enforcement agencies, our mental health providers, our healthcare providers to best respond to Minnesotans who are experiencing mental health crises. Thank you, Madam Chair, and thank you, members, for your time tonight. Thank you to all my testifiers. I ask for your yes vote.
All right, I will renew my motion that House File 3529 as amended be referred to the Human Services, Finance, and Policy Committee. The clerk will take the roll.
Beckerfin,
Aye.
Mueller, excused. Scott,
No.
Feist,
Aye.
Frazier, also excused. Grossel,
Aye.
Her,
Aye.
Hollins,
Aye.
Johnson,
Aye.
Liebling,
Aye.
Long,
Aye.
Mortensen,
No.
Novotny,
Aye.
Barr,
Aye.
Robbins, Representative Robbins, Bang,
Aye.
Zhang.
Aye.
That is 12 ayes and 2 nays.
All right, the motion prevails and the bill is on its way to Human Services. I thank you, members, for a very busy day. We got a lot of work done. My AirPods died, so I think that's a sign that we need to go home. Thank you very much. With that, we are adjourned.